Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone, and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and can you believe we're watching court on a Saturday? Like, it's not common, hey? The jury is sequestered, so that is why it's happening. They will be listening to the jury instructions. They're actually busy with it now. We'll catch up in a moment. And then they'll go off to deliberate, and this is in the... Sorry, I'm just adjusting the size. This is in the first phase of this trial, which is, of course, the guilt phase, and afterwards will be, if he's found guilty, the punishment phase, which is all about will he be sentenced to death or not. Now, before we get to the jury instructions that the judge is going to read, he said it's about 100 pages. And he said, I'll read it in about an hour, maybe 45 minutes. So let's see if that happens, right? There's a lot of pages to read. Oh, my goodness. He sounds like me. Sometimes when I'm like, this document's all right. It's like 100 pages. And I'm like, it'll probably be like, like an hour live stream. Let's read this. My voice will handle it. And then it's like 4 hours later. A 100-page document can take a while, but let's see. So please like and share so others know we are live right now. And yeah, especially because it's a Saturday. I wanted to quickly, this is what I was trying to show you yesterday, is the summary of, I actually showed you the CSAM charges. There's 18 of those. And so that's not part of this trial. This trial, you could see, this is from As the Gavel Drops. Sorry, it's a bit faint. So thank you to As the Gavel Drops for this document. So basically, you could see there's 13 charges. The jury of 12 will have to deliberate on those. They have to come to a unanimous verdict. I'm not a lawyer, so I don't know what happens if they decide on 8 and not the other 4 and all of that. Okay, so, but we'll see what happens and what they come back with, right? But they're going to have to deliberate on all these charges. There's 16 jurors, including the 4 alternates, 8 females, 8 males, all right? So, and the judge said that he's going to, let's see if he does that as well. He has a cup there, like a mug, and he said he's going to take 4 numbers out of the mug, and those will be the alternates, right? And they'll go into a different room, and he told them, please bring a book because you're going to have to keep yourself busy while the jury deliberates, right? Okay, so you can see here they've got different little codes for it and things like that. It says murder, first-degree felony, and then it repeats for count 1, 2, and 3. Then there's this RAPE, saying it for YouTube. So SA, aggravated. Okay, that's 1, 2, 3 as well. And then kidnapping, aggravated. And then especially aggravated kidnapping. And then aggravated, that word there. Conspiracy to commit first-degree murder. Conspiracy to commit aggravated RAPE. Conspiracy to commit aggravated kidnapping. Abuse of a corpse. And evidence tampering with or fabricating. Those are the 13 counts. They did read it to us on day 1 before the opening statements, and I did timestamp that for you. So if you just go check out the pinned comments or the description box on day 1 of this trial, you'll see the prosecutor read that to you. Just want to show you so you have a visual. I also want to show you one more thing quickly before we start the stream. Just hold on one second. I just want to do this one. Thank you to the person who sent me this just to remind me. I forgot to show you guys this. Okay, we've got it here. This is where Jennifer was buried. This is a stone. Shame, man. It's actually really beautiful. Look at all the flowers around and everything. They say, beloved mother, daughter, granddaughter, and sister, May 7th of 1984 to August 6th of 2020. August 6th was, of course, when her body was found. And they believe that she was murdered in December of 2019, right? Georgie says Rebecca, you're reminding everyone Rebecca is in prison for life plus 50 years. So she got life in prison for she pleaded guilty. Life in prison for the charges that Sean Finnegan, those ones we just went over. She was facing the same charges. So that, and then she got the plus 50 for those CSAM related charges, right? Okay. So before we get into this court day now, I just want to welcome all my moderators. Thank you so much for everything you do. I know trial days are very intense, very hectic, and we have a small team of moderators, but the best team. They're amazing. So thank you so much. Welcome to all my patrons, members, subscribers, any family and friends of Jennifer Paxton in chat as well, and anyone that's new over here. If you haven't seen the other days of the trial, please check out the trial prep that we did, because that'll give you a good overview of the case if you just don't know where to start. Of course, watch here with us today. This will be jury instructions, and then they're going to deliberate. So then we'll go to verdict watch, right? Ooh, and I wonder, let's see how you voted quickly. How long do you think the jury will deliberate for? So far, 639 people voted, and 56% think they will only deliberate for 1 to 4 hours. 34% say 4 to 8 hours. 6% say 8 to 12 hours, and 3% say 12 plus hours. I think I'm even part of that 3%. I'm like, this could take a while because there's so many charges as well. You know what I mean? Okay. Now, sorry, let me just bring this up. Anyway, go here, make this full screen, and I'll have to quickly resize it for us. Hold on a second. Otherwise, we can't see a damn thing, right? There's the judge. Okay. It looks like the other news stations are not really... I haven't seen them streaming this today. Maybe I'm wrong. I didn't see it. It looks like it's Law and Crime's camera person on duty today. So thank you to Law and Crime. I'm putting myself just here so it's just a less busy screen, okay? I'm not being disrespectful to Law and Crime. There we go. How about that? Are we ready? Okay? So I will always link the original stream if you don't like commentary, okay? Here we go. So the judge has just arrived.
Now, I've given you all a copy of your jury instructions. Let me ask you this, though, to make sure. You remember my instructions before? We've talked about it several times. We're not supposed to talk to each other about the case until we've gotten all the law and all the facts and all that. So everybody agrees with me that you do not speak to each other or anybody else about this case. Last night while you all were gone, everybody just raise your hand on that. Thank you very much. So today what I'm going to do is, by law, I've got to read you these instructions. So, and I read pretty fast, which is a problem. So if I skip a word, you need to go by what's in this document, not by my speaking. And if I mess up the pronunciation of a word, which I'll do sometime, go by what's in the written document. And you don't have to follow along. You'll take this back there with you when you begin your deliberation, but whatever makes you comfortable. Some people are better learn more from listening. Some people are better from reading, so it's just kind of up to y'all. Everybody understand that? So as I read this to you, I'm not sure how long it'll take, but if you need to take a break.
Listen, Judge, yesterday you said 45 minutes to an hour, and we're going to start our timer. We want to know, can you do it? I want to know if he's an eternal optimist like me with documents. Obviously, I think he's read a lot more documents in his life, honestly. But he's like, 45 minutes to an hour. Let's see, 100 pages. Okay, here we go. You can see he's coughing. He's getting that voice ready, okay?
We're going to do this for a bathroom break. Just raise your hand, and I'll stop what I'm doing. Deal? Okay. All right. Let's get started on this. The defendant, Shannon Finnegan, is charged in indictment C1C0051A with the crimes of first-degree premeditated murder, first-degree felony murder, aggravated rape, aggravated kidnapping, especially aggravated kidnapping, abuse of the corpse, and tampering with evidence. Count 1 charges the defendant with the offense of first-degree premeditated murder of Jennifer Paxton. The offense necessarily includes the lesser offenses of facilitation of first-degree premeditated murder, second-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 2 and 3 charge the defendant with the offense of first-degree felony murder of Jennifer Paxton by alternative means. Count 2 charges felony murder during the perpetration of or attempt to perpetrate aggravated kidnapping. And count 3 charges felony murder during the perpetration of or attempt to perpetrate aggravated rape. Each of these offenses necessarily includes the lesser offenses of facilitation of first-degree felony murder, second-degree murder, facilitation of second-degree murder, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 4, 5, and 6 charge the defendant with the offense of aggravated rape. Each of these offenses necessarily include the lesser offenses of attempted aggravated rape, facilitation of aggravated rape, rape, aggravated sexual battery, attempted rape, facilitation of rape, attempted aggravated sexual battery, facilitation of aggravated sexual battery, facilitation of attempted aggravated rape, facilitation of attempted rape, facilitation of attempted aggravated sexual battery, attempted sexual battery, and facilitation of sexual battery. Count 7 charges the defendant with the offense of aggravated kidnapping. This offense necessarily includes the lesser offenses of attempted aggravated kidnapping, facilitation of aggravated kidnapping, kidnapping, attempted kidnapping, facilitation of kidnapping, facilitation of attempted aggravated kidnapping, facilitation of attempted kidnapping, false imprisonment, and attempted false imprisonment. Count 8 charges the defendant with the offense of especially aggravated kidnapping. This offense necessarily includes the lesser offenses of attempted especially aggravated kidnapping, facilitation of especially aggravated kidnapping, attempted aggravated kidnapping, facilitation of aggravated kidnapping, facilitation of attempted especially aggravated kidnapping, attempted kidnapping, facilitation of kidnapping, facilitation of attempted aggravated kidnapping, facilitation of attempted kidnapping, false imprisonment, and attempted false imprisonment. Count 9 charges the defendant with the offense of conspiracy to commit first-degree premeditated murder. This offense necessarily includes the lesser offenses of conspiracy to commit secondary murder and conspiracy to commit voluntary manslaughter. Count 10 charges the defendant with the offense of conspiracy to commit aggravated rape. The offense necessarily includes the lesser offenses of conspiracy to commit rape, conspiracy to commit aggravated sexual battery, and conspiracy to commit sexual battery. Count 11 charges the defendant with the offense of conspiracy to commit aggravated kidnapping. This offense necessarily includes the lesser offenses of conspiracy to commit kidnapping and conspiracy to commit false imprisonment. Count 12 charges the defendant with the offense of abuse of a corpse. This offense necessarily includes the lesser offense of attempted abuse of a corpse and facilitation of abuse of a corpse. And count 13 charges the defendant with the offense of tampering with evidence. The offense necessarily includes the lesser offense of attempted tampering with evidence, facilitation of tampering with evidence, and facilitation of attempted tampering of evidence. The defendant pleads not guilty to each and every offense embraced in the indictment.
Okay, so 2 pages down, 98 to go. Do you see that? It's like, oh, is he grabbing his water now? What? Okay, so that's why I was saying I think this could take a while, you know? Unless they're all like absolutely convinced by what the state has shown that, this guy's guilty of everything, then they'll be back quick. But if not, whoa, there's a lot of charges and a lot of paperwork to discuss. I smile because I know what it feels like. It's like, oh, damn, I'm going to get that water going. Here we go. 98 to go.
The evidence in this case has been completed, and it's my duty to now instruct you as to the law. The law applicable to this case is stated in these instructions, and it's your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of others, or others, but should consider each one in light of and in harmony with the others. Whenever a singular of a word is used in these instructions, it may be taken equally to mean plural. Wherever the word he is used in these instructions, you may consider it as applying equally to a woman or an entity such as a corporation. The indictment in this case is the formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. At times during the trial, I've ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, or nor any remarks which I have made do I mean to indicate any opinion as to the facts or what your verdict should be. Statements, arguments, or remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case, and also you are the exclusive judge of the law or the direction of the court. You should apply the law or the facts and assign the case. You should consider all the evidence in light of your own observations and experience in life. You as jurors must decide the case based solely on the evidence presented to you within the four walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, blogs, use any other electronic tools to obtain information about the case or to help you decide the case. Please do not try to find out any information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss the case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you return a verdict and the case is at an end. I hope that for all of you, this case is interesting and noteworthy. I know that many of you have used cell phones in the past, Blackberries, the internet, and other tools of technology. You also must not talk to anyone else about the case or use these tools to communicate electronically with anyone in the case. This includes both your family and friends. You may not communicate with anyone about the case on your cell phone, through email, Blackberry, iPhone, text message, or on Twitter or X, through any blog or website, through any internet chat room, or by way of any other social networking website, including but not limited to Facebook, MySpace, LinkedIn, and YouTube. The law presumes the defendant is guilty of the charges against him. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and is not overcome unless from all the evidence in the case you're convinced beyond reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the proof necessary to constitute the offense. During the trial, many of you have taken notes concerning the evidence presented to the court. These notes are simply to assist you in remembering what transpired in court. Your notes are not evidence or a transcript of the testimony. They are not a substitute for your recollection of your evidence that you saw or you heard in court. You may use your particular notes during deliberations to the extent you think they are helpful, but the fact that a particular juror has taken notes does not mean that juror's views should be given any greater weight than those of any other juror. The state must have proven beyond a reasonable doubt all the elements of the crime charged, and that was committed before the finding and returning of the indictment in this case. The burden is upon the state to prove by preponderance of evidence this offense was committed in Anderson County, Tennessee. Proof by preponderance of evidence means that the greater weight of evidence must be in support of the state's contention. Venue of the offense lies where the offense was commenced or consummated. If you find the state has failed to prove by preponderance of evidence that this offense was commenced or consummated in Anderson County, Tennessee, then he must return a verdict of not guilty. The defendant is criminally responsible as a party to the offenses of first-degree premeditated murder, first-degree felony murder, aggravated rape, aggravated kidnapping, especially aggravated kidnapping, abuse of the corpse, and or tampering with evidence. If the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both, each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to the benefit of the proceeds or results of the offense, the defendant direct, aids, or attempts to aid another person to commit the offense.
Sorry, just a quick pause there. Ed says, rocking with Grizzly on a Saturday morning in Western NC. Thank you for being here. Thank you all for being here on a Saturday for another trial day, day 5. Of course, they just got jury instructions here. It's going to be quite lengthy, as we could see that pile of paper in front of the judge. And so that's what they're doing. And then it'll obviously will be on verdict watch. Yesterday, I asked you guys, comment below if you watched the whole day with me. And so many of you did. Thank you so much for staying with us the whole day, watching the whole trial with us, and also seeking justice for Jennifer. I hope that her family feels supported, and they know there's people all over the world that also want to see justice for their Jennifer Paxton, right? So, and I hope they will be. And, Can you imagine being on the jury and being like, damn, that's a lot of charges? We don't always see such a long list, right? This is a long list of charges. My goodness.
A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another, if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. With regards to count 2 and 3, charging the defendant with murder and perpetration of aggravated rape and aggravated kidnapping, respectively, this natural and probable consequences rule does not apply. There is no requirement that the killing be foreseeable in order to hold the defendant criminally responsible, only that the defendant intended to commit the alleged aggravated rape and aggravated kidnapping, respectively. To find a defendant criminally responsible for the acts of another, it is not necessary that you find that the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find all the essential elements of said offense have been proven by the state beyond a reasonable doubt. Facilitation of felony. Any person who commits the offense of facilitation of felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific felony, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the felony. And 3, that the defendant furnished such assistance knowingly. Here, knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct, and the person is aware of the nature of the conduct or the circumstance exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intent means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it's a person's conscious objective or desire to engage in the conduct or cause the result.
Ace, thank you for that. You say jury sequestration is when a judge isolates a jury from the public and press during a trial to prevent them from being influenced by others. This is usually done in high-profile criminal cases. So the jury, in this case, is sequestered, and I believe they're staying at a hotel, so they're not going home, to their families every day. As you say, they're isolated from the public and the press. And so that is why this includes Saturdays as well. Like the Delphi trial, the trial of Richard Allen will also be like that. Judge Gold also said they're going to have to work on Saturdays, probably, because they're going to be sequestered, right? Okay. Melissa Loves True Crime says, stay hydrated, Judge. Yes, yes.
Criminal attempt. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense, and 2, that the defendant in some act intended to complete a course of action or cause a result that would constitute the offense or the circumstances as the defendant believed them to be at the time, and his actions constitute a substantial step towards the commission of the offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the offense. Here, intended, and intent means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute an offense which attempt is a lesser included offense, are set out within these instructions on that offense. Count 1, first degree premeditated murder. Any person who commits the offense of first degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim. And 2, the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement or passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt the defendant is guilty of premeditating the first-degree murder, then it is your duty, after a separate sentencing hearing, to determine whether the defendant will be sentenced to death, life imprisonment without possibility of parole, or life in prison. But you will not consider punishment for this offense at this time. If you find from the proof beyond a reasonable doubt the defendant is guilty of first-degree premeditated murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of first-degree premeditated murder as charged during the indictment, then your verdict must be not guilty as this offense, and then you will proceed to determine his or her guilt or his guilt or innocence of facilitation of first-degree premeditated murder, a lesser included offense. And this too will be listed on the verdict form. The essential elements necessary to constitute facilitation of felony and premeditated first-degree murder have previously been set out in these instructions. If you find from the proof beyond a reasonable doubt the defendant guilty of facilitation of first-degree premeditated murder, you shall so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree premeditated murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. The lesser included offense of second-degree murder. A person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim, and 2, the defendant acted knowingly. Knowingly means a person acts with awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second degree is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the indictment, then your verdict must be not guilty as this offense, and then you shall proceed to determine the guilt or innocence of facilitation of second-degree murder, a lesser included offense.
Skeeter is asking, question, is the jury sequestered through the penalty portion of this trial too? I actually don't know the answer. If anyone knows the answer, let me know. I can only assume so because they've been sequestered for this first phase, but I don't actually know. So if anyone knows, if you know how it works with a death penalty trial in Tennessee, this happened in Anderson County, Tennessee, let us know in chat.
The essential elements necessary to constitute facilitation of felony or secondary murder have previously been set out in these instructions. Refer to these instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of secondary murder, you will so report that on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of secondary murder as charged in the indictment, then your verdict must not only be as to the offense, then you shall proceed to determine his guilt or innocence of voluntary manslaughter, a lesser included offense. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of the crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim, and 2, the defendant acted intentionally or knowingly, and 3, the killing resulted from a state of passion produced by an adequate provocation sufficient to lead to a reasonable person to act in an irrational manner. Again, the distinction between voluntary manslaughter and secondary murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally and knowingly have been defined for you in instruction on secondary murder. Please refer to those definitions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged in indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of voluntary manslaughter as a lesser included offense. Facilitation of voluntary manslaughter. The essential elements necessary to constitute facilitation of a felony and voluntary manslaughter previously been set out in these instructions. Refer to these instructions here. If you find from the proof that beyond a reasonable doubt that the defendant is guilty of facilitation of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of voluntary manslaughter as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall not proceed to determine his guilt or innocence of. Then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant killed the alleged victim, and 2, the defendant acted recklessly. Recklessly means that a person acts recklessly when a person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that this disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally or knowingly have previously been defined for you in instructions on secondary murder. Please refer to those definitions here. If you find beyond a reasonable doubt the defendant guilty of reckless homicide, you will so report on your verdict form. If you have found a reasonable doubt as to the defendant's guilt of reckless homicide as charged in indictment, then your verdict must be not guilty as to those offenses, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense.
Georgie 1 says, on a positive note, we made it through closing arguments. Oh, my word. If you guys did not see that, I timestamped that for you yesterday as well. Oh, my goodness. Like, wow, the state started off so strong, and then it went a little bit, it got a little confusing, went a little downhill from there. Sort of picked up again, and then, the defense, it was long, guys. It was long. It was very exhausting. I do have trial babalas today, which means like trial fatigue. Very tired. My goodness. Are any of you tired as well? This case has been intense. And then those closing arguments, that was just like, oh man. And then now it's like 100 pages of instructions. I mean, Wow. Thank you so much all for being here. Please like and share so others know that we are live right now. Of course, YouTube will not be promoting the stream whatsoever with all the naughty words that are being said here by the judge. It's not his fault. But please, you guys are the only ones who, if you like and share, then others will see it. If you don't do that, then no one will really find the stream at all. So, all right. I have lost count of how many pages he's put here now, but it's about 8 pages or so. And he's 27 minutes in from when he started. And he said it'll take him about 45 minutes to an hour to read. So let's see. I think it'll take longer. Okay, here we go.
Facilitation of reckless homicide. The essential evidence necessary to constitute facilitation of a felony and reckless homicide previously been set out in these instructions. Refer to those instructions here. If you find from your proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant's conduct results in the death of the alleged victim, and 2, the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unsubstantial risk, unjustifiable risk, substantial and unjustifiable risk that the alleged victim will be killed. The risk may be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person will exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally and knowingly are defined these instructions on the second-degree murder. Recklessly is defined these instructions on reckless homicide. Refer to those definitions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you will so report that your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in this indictment, then your verdict must be guilty as to this offense. And then you shall proceed to determine if his guilt or innocence of facilitation of criminally negligent homicide, a lesser included offense. The essential elements of necessary to constitute facilitation of a felony and criminally negligent homicide have previously been set out in these instructions. Refer to those instructions here. If from your proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminally negligent homicide, you will so report your verdict on the verdict form. If you have found a reasonable doubt as to the defendant's guilt on the facilitation of criminally negligent homicide as charged, then your verdict must be not guilty as to this offense. Counts 2 and 3. First-degree felony murder. Any person who commits first-degree felony murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim. And 2, the killing was committed in the perpetration of the attempt to perpetrate the alleged aggravated kidnapping, count 2, or the alleged aggravated rape, count 3, and that the killing was closely connected to the alleged aggravated kidnapping, count 2, or aggravated rape, count 3, and was not a separate, distinct, independent event. And 3, the defendant intended to commit the alleged aggravated kidnapping on count 2, or the aggravated rape in count 3. Aggravated kidnapping and aggravated rape are defined for you within these instructions. Refer to these instructions and definitions herein. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Considerations of such facts are as time, place, causation, is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated kidnapping, count 2, or aggravated rape, count 3. The killing may have proceeded, conceived with, or followed the aggravated kidnapping, count 2, or aggravated rape, count 3, and still be considered as occurring in the perpetration of the aggravated kidnapping, count 2, or aggravated rape, count 3. So,
Sorry to interrupt there. Penny Burn says, if they find him not guilty, I'm gonna faint. Can you imagine? I'd be scared. He sounds really scary. If he's found not guilty and can actually go out there and be back in society, scary stuff. Especially, but he won't though, because there's those CSAM charges, right? That he's still got to face, the 18 counts. And I mean, Rebecca got 50 years for that. And Sean Finnegan is 56 years old. So I think he's getting out.
so long as there is connection in time, place, and continuity of action. When one enters into a scheme with another to commit aggravated kidnapping, count 2, or aggravated rape, count 3, and death ensues, both defendants are responsible for the death regardless of who actually committed the killing and whether the killing was specifically contemplated by the other. Here, intentionally means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find from the proof beyond reasonable doubt that the defendant is guilty of first-degree felony murder, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to death, life imprisonment without the possibility of parole, or life in prison. But you will not consider the punishment for this offense at this time. If you find from the proof beyond a reasonable doubt the defendant is guilty of first-degree felony murder, you will so report that on your verdict form. If you have a reasonable doubt as to the defendant's guilt of first-degree felony murder as charged in the indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of facilitation of first-degree felony murder as a lesser included offense.
You can do it, Judge.
The essential elements necessary to constitute facilitation of felony and first-degree murder, felony murder have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of first-degree felony murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree felony murder as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. The essential elements necessary to constitute secondary murder have previously been set out in these instructions, and lesser offenses of count 1. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of secondary murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence in facilitation of secondary murder, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and secondary murder have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of secondary murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of secondary murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. The essential elements necessary to constitute reckless homicide have previously been set out in these instructions. In the lesser offenses of count 1, refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. The essential elements necessary to constitute facilitation of felony and reckless homicide have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide You shall so report your verdict on your verdict form. If you have a reasonable doubt as to the offense guilty of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. The essential elements necessary to constitute criminally negligent homicide previously have been set out in these instructions. In the lesser offenses of count 1, refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the indictment, then your verdict must be guilty as to this offense, and then you shall proceed. Let me read that again. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of criminally negligent homicide, a lesser included offense. The essential element.
Ashley R says, gonna build some Lego while listening to lovely Judge Ash's voice. Lurk mode activated. Sis, I'm jealous. Take us with you. You are taking us with you. Build some Lego for us.
What's necessary to constitute facilitation of felony and criminally negligent homicide have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminally negligent homicide, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense.
I wonder if they watched any of our streams, whoever it would be, the camera person, any of the state or the defense. I know sometimes they do, but I ask because they're really showing Sean Finnegan's face less. They showed it a lot yesterday, a lot less, and today as well. We haven't actually seen him, which is quite nice, though. It's quite nice, right? Thank you so much, Andrea Cooper. You said you're truly amazing all the time, and research you put into all your live streams makes you #1 in my opinion. Oh, thank you so much. A cold and windy Cape Town. Oh my word. Another South African in chat. Thank you so much for being here.
Counts 4, 5, and 6, aggravated rape. Any person who commits the offense of aggravated rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2, as to count 4, force was used to accomplish the act as the defendant was armed with a weapon or any article used or fashioned in a manner to lead the victim reasonably to believe to be a weapon, to wit, a baseball bat. Or B, as to count 5, the defendant caused bodily injury to the alleged victim. Or as to count 6, the defendant was aided or abetted by one or more persons, and that force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. An aider or abettor is one who advises, counsels, or procures or encourages another to commit a crime. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Force means the compulsion by the use of any physical power or violence. Sexual penetration means sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any other person, part of any person's body, or any object into the genitalia or anal opening of the alleged victim, the defendant's, or any other person's body, but the emission of semen is not required. Cunnilingus means a sex act accomplished by placing the mouth or tongue on or in the vagina of another. Fellatio means a sex act accomplished with the male sex organ and the mouth or lips of another. Intrusion of the alleged victim's mouth is not required. Victim means the person alleged to have been subjected to the criminal sexual conduct. Here, intentionally means a person's act intentionally with respect to the nature of the conduct or as a result of the conduct, when it's the person's conscious objective or desire to engage in the conduct or cause a result. Here, knowingly means a person acts knowingly with respect to the conduct or the circumstances around the conduct, when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to be the result. Here, recklessly means a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstance exists or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances is viewed from the accused person's standpoint. Election of offenses. The state has offered proof in this case in chief of more than one alleged committed offense committed by the defendant in or by one. Let's start that over. The state has offered proof in its case in chief of more than one act allegedly committed by the defendant or by one for whom the state alleges the defendant is criminally responsible, which the state alleges constitute an element of the offense of aggravated rape as charged in counts 4 and 5 and 6 of the indictment. To ensure a unanimous verdict, the law requires the state to elect which alleged act testified to the state that the state is relying upon for your consideration in deciding whether or not the defendant is guilty of the offense or any lesser included offense. The fact that the court has required the state to elect does not mean the court has found that the state has carried its burden of proving those allegations beyond reasonable doubt. That is for your determination. In this case, the state has elected to submit for your consideration as to count 4, the alleged act where Jennifer Paxton was hit with a baseball bat and forced to perform fellatio on Sean Finnegan. Members of the jury would consider only this alleged act to decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses in and charged in count 4. In this case, the state has elected to submit for your consideration as follows in count 5. The alleged act where Sean Finnegan sexually penetrated Jennifer Paxton with sex toys in the vagina of Jennifer Paxton, and Jennifer Paxton suffered bodily injury, to wit, bruising about her head, chin, arms, hips, and legs. Members of the jury would consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses charged in count 5. In this case, the state is elected to submit for your consideration as follows in count 6. The alleged act where Sean Finnegan is present when Rebecca Dishman had sex with Jennifer Paxton, and Sean Finnegan then received fellatio from Rebecca Dishman. Members of the jury are to consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses and charge included in count 6. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated rape, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you will proceed to determine his guilt or innocence of attempted aggravated rape, a lesser included offense. The essential elements necessary to constitute attempt and aggravated rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of the attempted aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence. A facilitation of aggravated rape, a lesser included offense. Facilitation of aggravated rape. The essential elements necessary to constitute facilitation of felony and aggravated rape have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated rape, you will so report on your verdict form. You'll so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you should proceed to determine his guilt or innocence of rape, a lesser included offense. Rape. Any person who commits the offense of rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1. defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2, the force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly.
Ooh.
Intentionally, knowingly.
Ooh, it got stuck for a second. Angela K, thank you so much. Is that a coffee? It's like tired. Thank you so much.
Recklessly were all defined for you in the instruction on aggravated rape. Refer to those instructions here. If you find from your proof beyond a reasonable doubt that the defendant is guilty of rape, you should so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of aggravated sexual battery, a lesser included offense. Aggravated sexual battery. A person who commits the offense of aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond the essential elements. 1, as to count 5, the defendant had intentional unlawful sexual contact with the alleged victim, in which the defendant intentionally touched the alleged victim's intimate parts or clothing covering the immediate area of the alleged victim's intimate parts. Or B, as to counts 4 and 6, the alleged victim had intentional lawful sexual contact with the defendant, in which the victim intentionally touched the defendant or any other person's intimate parts or clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2A, as to count 4, the defendant intentionally, knowingly, or recklessly used force to accomplish the act and was armed with a weapon or any article used or fashioned in a manner to lead the alleged victim reasonably to believe it to be a weapon, to wit, a baseball bat. Or B, 2B, as to count 5, the defendant intentionally, knowingly, or recklessly caused bodily injury to the alleged victim. Or, as to count 6, the defendant was aided or abetted by one or more persons and intentionally, knowingly, or recklessly used force to accomplish this act. Bodily injury, force, victim, intentionally, knowingly, recklessly were defined for you in these instructions on aggravated rape. Refer to those definitions here. Intimate parts include semen, vaginal fluid, primary genitalia area, groin, inner thigh, buttocks, or breast of a human being. Sexual conduct means the intentional touching of the alleged victims, the defendant, or any other person's intimate parts, or the intentional touching of the clothing covering the immediate area of the alleged victim, the defendant, or any other person's intimate parts. If that intentional touching can be reasonably construed as being for the purpose of sexual arousal or gratification. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated sexual battery, you will so report your verdict on your verdict form. And if you have a reasonable doubt as to the defendant's guilt of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of attempted rape, a lesser included offense.
This is another picture that Grizzly Cat found of Jennifer Paxton. She was so beautiful. Ed, the poll ended about half an hour ago or so because everybody realized how long these instructions are and how many charges there are. 13 counts in total. So for everyone that voted 1 to 4 hours, I see there's still people saying within an hour, 1 to 4 hours, whatever. That could still be, but we might do another poll at a later stage just to see if anyone changed their mind after hearing all of this. Thank you, Virgo.
Attempted rape. The essential elements necessary to constitute attempt and rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted rape, you will so report your verdict on your attempted verdict form. If you have a reasonable doubt as to the defendant's guilty of attempted rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine the guilt or innocence of facilitation of rape, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of rape, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of attempted aggravated sexual battery, a lesser included offense. attempted sexual battery. The essential elements necessary to constitute attempted and aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted aggravated sexual battery, as you charge in the indictment, then your verdict must be not guilty as this offense, and then you should proceed to determine his guilt or innocence of facilitation of aggravated sexual battery, a lesser included offense.
Just a quick pause for a little mental break for us so we stay awake, alert, everything. Not that this is boring, but it's just it's very long, right? So Harley, right, I said, is Sean an only child. So someone had emailed me and said that had known Sean in the past, that said there were 4 brothers and 1 sister. The father was a drifter, left the family when the kids were young. So Frances Finnegan, Sean's mother, raised them as best they could. They were in poverty all their lives. So then they also said that his oldest brother is also serving life in prison for a murder in Florida about 30 years ago by killing his neighbor while he was on drugs. The only real surviving members of this whole family is this person's niece and nephew, I think it is. So I'm just trying to as well, thank you to everyone who's emailing me. I love insight about people that knew them. Some people have emailed that knew, for example, Rebecca in high school and things like that, saying that, well, no one was really shocked when she was arrested for this because she was always a little bit strange in school, is what they said, right? They didn't think that she was capable of this, but she was a bit odd already then. And they said she spoke exactly the same way. That's how they remember her. Terry says justice for Jennifer. May she rest peacefully. Thank you so much. So, yes, so 4 brothers and a sister. And actually, they said also his other brother, the youngest one, just died in Tennessee about 2 weeks ago from cancer. Okay? He just passed away. And then they said, hold on one second. One of the other brothers was literally hit by a bus, is what they say. Hit by a bus, okay, and killed in Fort Lauderdale. Damn. Okay then, so I really appreciate all the insight. It's always interesting to piece together all the information I get just so we can try to understand, why are they this way? What happened to these people? Not that the trauma doesn't define what happened. That's still a choice, you know what I mean? What do they choose to do with their trauma in life? What is the trauma? Do they have any? What's their background like? What happened? Were there other crimes? Did people think that this could happen? You know what I mean? So, okay, here we go. Let's continue.
The essential elements necessary to constitute facilitation of a felony and aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated sexual battery, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated rape, a lesser included offense. The essential elements necessary to constitute facilitation of a felony, attempted aggravated rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of facilitation of attempted aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt or facilitation of attempted aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you're to proceed to determine his guilt or innocence of facilitation of attempted rape, a lesser included offense. The essential elements necessary to constitute a facilitation of a felony, attempted rape, have previously been set out in these instructions. Refer them to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted rape, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated sexual battery, a lesser included offense.
So if I'm understanding correctly, if there's 4 brothers and a sister, I think the 4 brothers would include Sean Finnegan. 1 was hit by a bus. 1 died from cancer. So I don't know if 1 brother's still surviving, I think. But then Sean Finnegan's mother, she also passed away, as did his sister. And that's also like so strange because, you know, I don't know what the circumstances were. She's like, the mother, when Sean Finnegan was arrested, moved in with with her daughter, and then both of them passed away, you know, one shortly after the other. So that's quite interesting, right? Okay.
Facilitation of attempted aggravated sexual battery. The essential elements necessary to constitute facilitation of a felony attempted aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted aggravated sexual battery, you report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted aggravated sexual battery as the charge in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of sexual battery, a lesser included offense.
I wonder if he like looks at the clock when he's looking like that while sipping. Yes, it's been 58 minutes, Judge. 58 minutes. Come on. You've got 2 minutes left. You said 45 minutes to an hour. I'm just joking, right? I joke because I also read documents, as you know. If you've been on this channel for quite some time, you know I love to read documents, but I'm always optimistic. You can ask Mr. Grizzly. I'm always like, oh, it'll be like half an hour. It's fine. It's like 100 pages, you know. Hours later. You could do it, Judge.
Sexual battery. Any person who commits the offense of sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, as to count 5, the defendant had intentional or unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts. Or B, as to count 4 and 6, the alleged victim had intentional or unlawful sexual conduct with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts, or the clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2, force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. Force, intimate parts, sexual conduct, victim, intentionally, knowing, and recklessly were defined for you in these instructions of aggravated rape and aggravated sexual battery. Refer to those definitions here. If you find from your proof a reasonable doubt that the defendant is guilty of sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of sexual battery is charged in the indictment, then your verdict must be not guilty as to this offense. And then you'll proceed to determine his guilt or innocence of attempted sexual battery, a lesser included offense. The essential elements necessary to constitute attempted sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find from the proof that beyond a reasonable doubt that the defendant is guilty of attempted sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilty of attempted sexual battery as charged in the indictment, then you must return a verdict of not guilty as this offense, and then you shall proceed to determine the guilt or innocence of facilitation of sexual battery, a lesser included offense. Facilitation of sexual battery. The essential elements necessary to constitute facilitation of a felony and sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of sexual battery, you shall report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of sexual battery is charged, then your verdict must be not guilty as to this offense. Everybody okay? Nobody need a break? Still good?
Shame. I think the judge needs a break. He needs a refreshing rooibos tea break. Rooibos tea with lemon and honey. Yes, sir. We know that it gets quite straining, on the voice box there to read all these pages. I think they do take a break actually, which is great that we started 12 minutes late and it looks to me like they took a 10-minute break. How perfect is that? So we'll just teleport over that. Let's see. Yeah, there's still a few more minutes and then they take a break. Look. So we'll just skip over that and carry on.
Okay. Aggravated kidnapping, count 7. Any person who commits an aggravated kidnapping is guilty of a crime.
Or it gets stuck.
The following essential elements.
Okay, no.
1,
carry on.
the defendant knowingly removed or confined another unlawfully so as there to interfere substantially with the other person's liberty. And 2, the defendant did so to facilitate the commission of aggravated rape. The essential elements necessary to constitute aggravated rape are previously set out in these instructions. A removal or confinement in fraud. Force means compulsion by the use of physical power or violence. Fraud is defined, this term is used in ordinary conversation and includes, but is not limited to deceit, trickery, misrepresentation, and subterfuge. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. The definitions of knowingly and intentionally.
Shame, it's like glitching a little bit. Let's see. Okay, interesting. Let's make it. And it's only Law and Crime's camera person there today, it looks like. No other news people. Oh. Oh, damn. It literally got stuck. Okay, we're going to miss some of it. At least we've got the document to show all the charges that we looked at. Okay, signal's back. Wow, never mind. They didn't take a break. They just got stuck for 10 minutes or so. What? Jenny Dawn, I was wondering what you're talking about. Probably this, right? Okay.
Imprisonment, a lesser included offense. Attempted false imprisonment, kidnapping. The essential elements necessary to constitute the attempted false imprisonment have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted false imprisonment, you will so report your verdict on your verdict form. If you find a reasonable doubt as to the defendant's guilt of attempted false imprisonment as charged in the indictment, then your verdict must be not guilty as to this offense.
Yes, Judge, you can do it.
Stand up for me. If I need to stand up. Yep. Everybody good? Okay. So if I stand up while I'm talking, that's okay. All right?
Yeah, yes, Judge.
Yeah, stand up. We can exercise. We can do some stretches and stuff like that.
Everybody get your star jumps in. I like this judge. Look at him. He's like, we can exercise. Everybody do a stretch. Everybody, 1, 2, 3. Okay, if you are not, I'm going to stay seated. I always feel like, I'm sure you guys have noticed, I'm always like, I should get up for my health like every hour, but I'm just like glued to the screen. The entire trial day, I just like, I can't leave. Here and there, I'm like, I have to get more water. But anyway, so it's good. It's good that the judge is like, I need to stand up a little bit. Okay, take a deep breath. Let's carry on.
All right, count 8. Special aggravated kidnapping. Any person who commits a special aggravated kidnapping is guilty of a crime. We find the defendant guilty of this offense, and the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, the confinement or removal was accomplished with a deadly weapon or by display of any article used or fashioned to lead the alleged victim to reasonably believe it was a deadly weapon, to wit, a baseball bat. A removal or confinement is unlawful if it's accomplished by force, threat, or fraud. Force and fraud are defined for you in the instruction on aggravated kidnapping, count 7. Please refer to those definitions here. Here, violence means the evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawfully point a deadly weapon at an alleged victim is physical force directed toward the body of the victim. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. The definitions of bodily injury, knowingly and intentionally, have previously been defined for you in these instructions on aggravated rape. Refer to those instructions herein. Although the law requires no specific period, time of confinement, or distance of removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, the aggravated kidnapping, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than necessary to commit the offenses of premeditated first-degree murder, felony murder, count 3 only. Aggravated rape is charged in counts 1, 3, 4, 5, and 6. And in making this determination, you may consider all the relevant facts and circumstances of the case, including but not limited to the following factors. A, nature and duration of the alleged victim's removal or confinement by the defendant. B, whether the removal or confinement occurred during the commission of the separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in its objective. And F, whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape, and their lesser included offenses, and was not essentially incidental to it, you must find the defendant not guilty of especially aggravated kidnapping. You will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of attempted especially aggravated kidnapping, a lesser included offense. The essential elements necessary to constitute attempt or especially aggravated kidnapping have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as this offense, and then you shall proceed to determine his guilt or innocence of facilitation of especially aggravated kidnapping, a lesser included offense.
I see people are self-snitching, as Bruce Rivers will say, self-snitching that they didn't do their homework, asking why is this the special judge? So this is what the reason was that I found. They said Knox County Judge Stephen Sword was designated as the judge in this case, but he recused himself because of many cases pending in the Criminal Court Division 1 of Knox County. So normally, like in Delphi, when there's then a special judge assigned, it's because they may be from a different county, but then they're assigned to the case, so they call them Special Judge John R. Ash. Okay, so that is why. We did cover that in the trial prep. So if there's any questions, just about the case, if you want to know the timeline, a good overview of it, what the attorneys' names are, things like that, it's all on the trial prep episode. And I made sure to keep that under an hour. Okay, you could watch it at 1.25 speed and power through that and get lots of information quick. Okay.
Facilitation of aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony and especially aggravated kidnapping have previously been set out in these instructions. Please refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of aggravated kidnapping, a lesser included offense.
Just a quick pause. Frida, do I say it like this? Frida van der Biesen. Did I say it right? Or is it you're in America, then it's like Frida van der Biesen. Anyway, you said, of course he's guilty, but Rebecca was the mastermind. Thank you for sharing your opinion. You know what the thing is? Of course, the jury doesn't know about the the past charges that he has. But in 2015, he allegedly kidnapped a woman. He was arrested for that. They say he spent a short time in jail for that. I'm still trying to find out, well, how long and why so short. But according to that alleged victim, it was very similar. Also, and that's way before he met Rebecca. So I still think he's the mastermind here because he's done it before. And I don't know how many other victims there could be, but he'd kidnapped someone, chained them up, repeatedly SA'd them. They had injuries all over their body. They had called 911 and the way they got away was saying, I need to get back home to pick up my daughter. And from what I've read further, it's almost as if the lady was saying, we can pick up my daughter. And it's as if the way that the articles are written, it's almost as if it's implying that, don't worry, we can get someone else to join us too. Then there'll be like 3 of us. And he was like totally game for that. But on the way, somehow she got out of the car and called 911. And so they helped her, right? So I think obviously the jury doesn't know that. They don't know about that. But for us, who knows that, it's kind of like, I think he's done it before. And I think Rebecca was part of it. But I wonder what else Sean Finnegan's done in his life. He lived in Florida before. There's a whole bunch of charges that we looked at yesterday from there. Not quite like this. That was more like DUIs, possession of drugs and things. I'm trying to say that fast for YouTube. Even though all the naughty words are here. I know it. Okay, let's not add to it. So, possession of firearms. There was battery charges as well because apparently he was married before and he has at least one daughter. And there was a lot of DV there, so there was a divorce and all of that. So thankfully that lady got away from him. So, man, and never mind that. If you didn't know, after the murder of Jennifer Paxton, Rebecca and Sean Finnegan abused 2 children. One was under the age of 3 and filmed content. They created CSAM content. So that's how they busted them for that. So Rebecca pleaded guilty. She got life in prison and then plus 50 years for the CSAM charges. I don't know if she'll have to testify again in the punishment phase to talk about that, because people are saying in the chat that that's probably going to come up in the punishment phase, you know? So that'll be interesting to see that. I wonder. Okay.
Include offensive count 8, aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with others' liberty. And 2, the defendant possessed or threatened the use of a deadly weapon, to wit, a baseball bat. A removal or confinement is unlawful if it's accomplished by force, threat, or fraud. Force or fraud have previously been defined for you in the instruction on aggravated kidnapping in count 7. Refer to those definitions here. Violence and deadly weapon have previously been defined for you. I think I've already done that. I'm sorry. The definition of bodily injury knowingly and intentionally have been previously defined for you in the instructions of aggravated rape. Refer to those definitions herein. Although the law requires no specific period of time for confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this aggravated kidnapping, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense. A premeditated first-degree murder, felony murder, count 3, aggravated rape is charged or included in counts 1, 3, 4, 5, and 6. In making this determination, you may consider only the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement as defendant. B, whether the removal or confinement occurred during the commission of a separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. Whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether removal or confinement reduced the defendant's risk of detection, and although the defendant need not have succeeded in this objective. And F, whether removal or confinement created significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape was not especially incidental to you, you must find the defendant not guilty of aggravated kidnapping.
You can do it, Judge. Home stretch. That that little pile of paper is getting real thin there. He's working through all of that. Karen said, is Sean going to be charged with the children's death too? He didn't kill them. He didn't kill children. He sexually abused children with Rebecca. That's what those charges are. There's 18 counts of that. My goodness.
If you find from the proof beyond reason.
To clarify, not part of this trial. It hasn't been brought into this trial. But some people have said in chat that it may be brought up in the punishment phase. That'll be interesting. And if Rebecca Dishman has to testify again to that, wow, that'll be interesting as well.
Reasonable doubt that the defendant is guilty of aggravated kidnapping, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated kidnapping as charged in indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of attempted aggravated kidnapping, a lesser included offense. The essential elements necessary to constitute the attempted and aggravated kidnapping have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated kidnapping, you'll report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted aggravated kidnapping as charged in indictment, then your verdict must be not guilty of this offense, and then you'll proceed to determine guilt or innocence of facilitation of aggravated kidnapping, a lesser included offense. Facilitation of aggravated kidnapping. The essential elements necessary to constitute facilitation of felony and aggravated kidnapping have been previously set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated kidnapping as charged in indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of facilitation of attempted aggravated kidnapping. The lesser included offense of facilitation of attempted, especially aggravated kidnapping. The essential elements necessary to constitute facilitation of felony, attempted, especially aggravated kidnapping have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted, especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated special kidnapping as charged in indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of kidnapping, a lesser included offense.
I think he's almost done. Alex says, I hate to ask, but what page is the judge at? I think he's almost finished. There was about 8 minutes there where the cameras had a bit of a technical problem, so we missed some of that. We teleported through it, thank goodness. Otherwise, we'd be like, what is going on? We would have been worried if we were like live at the time, like what is going to happen now? Thankfully, the cameras came back on, but I think the judge is almost through it now.
Kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, the removal or confinement was under circumstances that exposed the other to serious bodily injury. Again, removal or confinement is unlawful if it's accomplished by force, threat, or fraud. Although the law requires no specific time or specific period of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant, or the distance of removal is considerable. To find the defendant guilty of this kidnapping, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of premeditated first-degree murder. Felony murder and aggravated rape is charged in counts 1, 3, 4, 5, and 6. In making this determination, you may also consider the relevant facts and circumstances of the case, including but not limited the nature and duration of the alleged victim's removal or confinement by the defendant, whether the removal or confinement occurred during the commission of a separate offense, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense.
Ooh, it looks like there's one more page. I'm putting the lighthouse there. If you guys missed where the judge shared kind of his mantra, like be the lighthouse. It was so nice. I timestamped it. I think it was from yesterday. So that would be day 4 of the trial. Just check the pinned comments or the description box or hover over the video somewhere near the beginning there. Easy to find because of the timestamps, but he's being the lighthouse right now. You can do it, Judge. That's a lot of charges to read. Of course, I know it's his job. I know he's just doing his job, but I think he's doing a fantastic job, right? Also, one love. Only in this trial, hey, will we see a sentence like that? Damn. You're like, in my opinion, Rebecca played being submissive, but was also dominant too. He did have her, let's say, cuck on him too. Yeah, we heard some bad things in this trial.
D, whether removal or confinement prevent the alleged victim from summoning assistance, although the defendant may not have succeeded in preventing the alleged victim from doing so. Whether removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective. And F, whether removal or confinement created significant danger or increased the alleged victim's risk of harm, independent of that posed by the separate offense. Unless you found beyond a reasonable doubt the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape, and was not essentially incidental to it, you must find the defendant not guilty of aggravated kidnapping. The definitions of bodily injury, knowingly and intentionally, have previously been defined for you in instructions on rape. Refer to those definitions here. Fraud, violence, and force have previously been defined for you in instructions on aggravated kidnapping above. Refer to those definitions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of kidnapping, you shall report your verdict on the verdict form. If you have a reasonable doubt as the defense guilty of kidnapping is charged in the indictment, then your verdict must be not guilty as this offense, and then you should proceed to determine his guilt or innocence of attempted kidnapping, a lesser offense.
Everybody, a big round of applause. The judge did it. Okay. So let's see. Oh. We didn't fall. That sounded like whoosh. Where's the sound? Where's the sound gone? Where'd the judge go? Okay, he's back.
The lesser included offense of attempted kidnapping. The essential elements necessary to constitute attempted kidnapping is...
Okay, sorry. Oh, he's fetched another page. Fletcher Boy, I didn't say that those charges are before this. They're after this. They happen in May of 2020. We've been over that before many times during this trial, including the trial prep, right? So it happened in May of 2020. He has not been tried for them yet, but some people say that it's going to be brought up in the punishment phase for some reason. I don't know because I'm not a lawyer, so I don't know. To me, what the charges that he's facing in this trial are the ones that the 13 counts that they've read out, right? And this is the guilt phase. If they find him guilty on these charges, they'll go to the punishment phase. Then that'll be all about, if he's going to be put to death or not. So at some point, he may be tried on those other charges, or maybe they'll ask him then if you want to plead guilty to these or what. Because Rebecca pled guilty to those charges. 18 counts of abuse of children, like terrible charges, okay? I showed some of them to you yesterday. And she's got 50 years on top of her life in prison, plus the 50 years for those charges related to the children, right? So... yeah, I mean, I'm thinking after this trial is done, then they'll tackle that, as far as I understand it. But let's see what happens in the punishment phase if the jury finds him guilty.
Previously set out these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of attempted kidnapping, you will so report your verdict on the verdict form. If you have a reasonable doubt as the defendant is guilty of attempted kidnapping as charged in the indictment, then your verdict must be not guilty as this offense, and then you proceed to determine his guilt or innocence of facilitation of kidnapping, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and kidnapping have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of kidnapping, you'll so report your verdict on your verdict form. If you have a reasonable doubt as to the defense guilt of facilitation of kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated kidnapping. Facilitation of attempted aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony, attempted and aggravated kidnapping have been previously set out in these instructions. Refer to these instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as the defense guilty of facilitation of attempted aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilty or innocent of facilitation of attempted kidnapping, a lesser included offense.
Oh, my word, Fletcher boy is reminding us. We thought Jessica Krzyzewski, was almost finished during sentencing till she grabbed another stack of papers. I almost like blanked that out. It's as if I forgot because that was painful. That was, could not believe it. Couldn't believe. Oh my word. Remember, actually, you know what? We skipped some of that, right? We were like, no, we're not going to listen to her cuck anymore. That was so long. Oh my goodness.
Facilitation of attempted kidnapping. The essential elements necessary to constitute facilitation of a felony, attempt and aggravated kidnapping have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you will proceed to determine his guilt or innocence of false imprisonment, a lesser included offense.
We're on page 52. I'm just kidding. You'll be like, what? How many more? Yeah, 52. So we're only just over halfway. No. I think the judge is almost there. I don't know because we know he's not reading out the pages. We can't see the pages the whole time, so it's a bit of a guessing game, but it's okay. I really enjoy being here with you. Hope you enjoy being here with me. Thank you all for being here with us on a Saturday for trial time. That's new. I mean, new for us, not new in the world.
Tell us where to break for lunch. What do you think? So, we're going to see. What we'll do is we'll finish this up when you come back from lunch. But during lunch, you don't have all the law. I've not picked the alternate. You can't start the deliberate. So when you're eating your lunch, you can't talk to your fellow juror about the case. Everybody agree not to do that. That'd be fine. Thanks for doing that. So we'll take I'll let y'all be back here at 1:15, and then hopefully what we'll do is I probably got another 30 minutes to charge it to do. I'll do that. Then we'll pick our alternates, and then 12 jurors can start their deliberation. All right? So see y'all back here at 1:15. You can leave your instructions just there.
All rise.
No. We don't like fluff. We don't like it. Now we're part of the fluff. Okay, so that was on my little stopwatch here, 1 hour and 29 minutes, and there was 8 minutes that we skipped. So 1 hour and an hour, let's call it an hour 38, okay, is how long the judge has taken so far to read that document that he was like, I'm a quick reader. It'll take 45 minutes to an hour. And I say that again in case someone's only joining now, because I'm always optimistic as well. When I see documents, I'm like, it's easy. It's too easy. Okay, so we were 12 minutes behind. They're only coming back at, did he say what, quarter past? Did he say quarter past? 1:15. My word. No. Okay. We don't want a long break. Okay, so let us see what else happens here, and then I'll skip.
Anything from the state before we break for lunch?
There you are.
Anything from the defense? Okay, see y'all back at 1:15.
Thanks, Judge.
Thank you.
Yep, he said 1:15. We're so used to not having fluff and just teleporting. Now we're spoiled. Now I see what you're like, gee, you have spoiled us. We cannot watch trials like that anymore. Yeah, I'm like, no. So let's catch up here. Okay, let me refresh this feed so that we actually exactly where it is. So hold on 1 second. Okay. My word. Oh, and while I'm at it, there's always things to talk about at least. Okay, let me put the, just love it. The judge is like, yeah, guys, we're going to need a lunch break. Those documents, it's a lot, right? It's a lot. Chef lady's like, maybe squeeze in a nap. No, hell no, I'm not abandoning you. No. Kristen says take a lunch break. I already had lunch. I had lunch right before this. Remember, for me, it's 6 p.m. Is it? What? I'm like so confused. Yeah. It's 6:10 in the evening for me already. Lunch. Psh, that was long ago, guys. Hours. So what I want to show you quickly is, let's bring up these documents again. Yeah. Okay. So these ones are the charges. Did the judge get what count was he on there? Did you hear? How many counts? Did he read all the counts out or not? I feel like he may have read all the counts, but I'm not sure. And then maybe when they come back, they read actually all the instructions. Okay, let me take my trigger warning off here. All right. Loba says, I'm teletransporting to Australia. Is it teleporting to Australia? Rob's like, the judge really poked up for lunchtime. Yeah, he's got to refuel for the next round of those documents, right? Rexy says, what time is it there? A lot of people ask me that during all the streams. So just ask Uncle Google anytime, because it depends where you are watching. You know, if you're behind in the stream or what, just say time in Switzerland and then you'll know. For me, 6:10 in the evening, right? So Mr. Grandma is like, oh no, the seal. For hours, guys. No, not hours. Right now in Anderson County, Tennessee, it is 12:09. They're coming back at 1:15. And you know how it goes. I could go over the whole presentation again, okay? I could even chop it out if you guys want for the... I think I could, depending on how long the stream is. Sometimes on YouTube, if the stream is... They don't give you an exact time. If it's like over 5 hours, then you can't chop anything out. But anyway, so... Patty Brown says the sound is horrible. I can't hear it. Are you talking about me or the sound over there or where? I hope you guys can hear me, right? Mic check. Okay, so these are the counts that the judge has been reading out with all the different lesser charges and instructions and all the things, right? So count 1, well, actually, it's not, I don't know if it's in order. There's 13 of them. Murder, first degree, felony murder, and there's 3 of those. RAP, aggravated, 1, 2, 3 of those. Kidnapping, aggravated, especially aggravated kidnapping. Aggressive, is that aggressive? I guess assault. Aggravated assault, not aggressive. Aggravated, legal terms. Okay, thank you. I'm caught up. Conspiracy to commit first degree murder. Conspiracy to commit aggravated RAPE. I wonder if text messages will prove that at all. Or, you know, what is that based on? The conspiracy to commit. Because that would mean normally involving someone else, which plausibly would be Rebecca, right? And she said that he said, but I mean, that's her saying it. She said that he said, do you want to kidnap her? Do you want to kidnap someone? You know, so, okay. Conspiracy. Willow has come to join us now. Is it? Conspiracy to commit aggravated RAPE, kidnapping, abuse of a corpse, evidence tampering with or fabricating. Okay, so those are the 13 that the judge is reading through. The other charges, which actually, they're not prior charges, they're actually later charges that he will still have to face at some point, are these ones. Look at that. Well, there's actually 20 here. Aggravated RAPE of a child. Look at all of this. Exploitation of a minor. So, as Rebecca was saying, they used to babysit sometimes. And I don't know whose kids those were. They did talk about Sean Finnegan's ex coming over sometimes, which I think they called her Sarah. And she had 2 kids. So I don't know whose kids they were babysitting. But they did not babysit them very well. They did terrible things, right? So Rebecca's already pleaded guilty to all the charges. These ones, I know, these ones, and these ones. So she got life in prison plus 50 years. And I mean, whoa, she's 26 years old now. Sean Finnegan is 56. And he's still going to face these, I'm thinking, after this trial at some point, right? Okay. June says, curious, are there interesting trials in Switzerland or do they not stream trials? They don't stream it. It's like, it's so amazing how, I guess, for everyone in the USA, you just don't know how much you actually show. You know what I mean? Like, it's so awesome to see the trials, to get the documents, to do all the things. You can't generally get documents like that. Not in South Africa, not in Switzerland, not in the Netherlands when I was there. Some trials were streamed in South Africa, but not much, not much. It's quite rare, actually. So people always say, why do you only cover cases from the USA? Or mostly. I've covered cases from elsewhere, but mostly because we can actually see something. And we love map time. We love documents. We love press conferences. We love, of course, live streaming trials and hearings and all the procedures all along the way. It's actually really awesome to follow, you know? So, okay. I just want to see what she's doing. I don't know if you heard her. She's very naughty. She's doing zoomies now. Okay, so these are the charges, right? And yesterday we had a look at this that somebody had sent to me, an anonymous source, of course. And so thank you to the person who sent this to me. And so basically what it's showing is these are prior charges, which is obviously not part of this trial. But they talk about Sean Finnegan, okay, Class A misdemeanor. I'll also read you some of the emails that I received about Sean and about Rebecca, okay? So, IR Geek says, where are you sharing from? From Switzerland. So, Sean Finnegan, all right. I'm just going to go from the right column here. This was in 2021, Class A misdemeanor. So, oh yeah, this was first degree murder. So these are these charges, okay? Abuse of a corpse, okay, that's there. Of course, it would come up on a background check. And there's the mugshot, which we've already seen. We've seen it enough, right? Loba Volcano says in Spain is the same, not streaming. Yeah, there's not like, you know, in South Africa, we don't have such a thing as mugshots for the public to see. So even that, like mugshots, wow. I mean, it's just amazing to be able to see all of this and to participate in it and comment on it. It's really great. So, especially we've got these ones. Okay, we've got all these charges. That's for this trial. Tampering with evidence. So, we keep going. This is now in Florida because he had lived in Florida before. But you can see it's from 1997, this one. Misdemeanor, disobey or avoid traffic device. Misdemeanor, license suspension or revoked. Driving under the influence, fleeing a police officer, driving while intoxicated, fleeing a police officer. This one from 1993 says battery. I don't know if that's got to do with his ex-wife because apparently he was married, apparently he had a daughter, and apparently he was a DV aggressor, and that is what those types of charges are for. If that is so, I'm so glad that lady got away from him, right? Yeah, Hypnotizes Lobster says, I wonder if the CSAM might be considered as aggravating factors if or when found guilty. A lot of people in the chat have mentioned that, like locals, so I'm not sure if that's how it would work. Of course, you know, things work differently per state, and this is also, you know, death penalty trial. So there's first the guilt phase, and as you say, then it'll be the punishment phase where they have to present aggravating and mitigating factors. So I wonder if it will be brought up then. You know, that'll be interesting. Okay, so thank you, Jenny Peach. Thank you, everyone, for all the commentary that you make there as I'm reading this as well. Yeah, and Samantha, you're right. She got 50 years for the kids. I believe they were his ex-girlfriend's kids. They didn't really confirm that, but I don't know. Shame, man. Those poor kids. So this one was for 1993 for battery. Then this one, 97, is second-degree misdemeanor, driving with license suspended, revoked, cancelled, disqualified, disobeying or avoiding traffic device, license suspended, revoked, driving under the influence, fleeing a police officer, and then possessing, selling, or delivering diazepam. I actually wanted to look that up again. What is it again? Just try to censor words if you're writing them there. Okay, so diazepam is used to treat anxiety, alcohol withdrawal, and seizures. It's also used to relieve muscle spasms and to provide sedation before medical procedures. This medication works by calming the brain and nerves. Is it diazepam? Is it kind of like Xanax or no? Diazepam belongs to a class of drugs known as benzodiazepines. Okay. I just want to see, is it? Oh, the generic name for Valium is diazepam. So he had that. You guys are like Valium, a nerve pill. Okay, thank you so much. Thank you also for censoring that if you can. It does help. Otherwise, YouTube, you know, AI is analyzing the chat the whole time now. And then they see, is the person talking about what they advertise they would talk about based on the title and the thumbnail? Well, yeah, look at this trial. But also, like, what are people saying here? Is it a healthy stream? Is it good? Is it good for YouTube? PG-13 platform. So that's why we ask you to just please censor names, if you can, of, like, substances. Miss Molly Australia says, no live streams in Australia either. They do have mugshots, though. Yeah, we don't even have mugshots in South Africa. I've never seen one in Switzerland. I don't know if they have them either. Okay, so he had that, and then driving under the influence, fleeing a police officer, possessing, selling, delivering again diazepam, driving under the influence, fleeing a police officer. It's like, wow, he repeats patterns, huh? At least we can gather that from this. Driving while intoxicated, possession of diazepam again, fleeing a police officer, driving while intoxicated. You see that. It's just like the whole time. So if he repeats things like a pattern, I wonder if he does it as well with the kidnapping and all that. Because he did kidnap someone in 2015, right? Okay, I'll show you a little clip of that actually as well. Just hold on 1 second. I just want to see. Somebody sent me something. Where is it? Yeah. Thank you to... I always keep my sources anonymous, but you know who you are. So thank you for sending like the news clips and things. Okay, the local ones from Florida. I'll show you guys that in a moment. So, here they go. Possession of a firearm. Okay. Battery. Again, this was from 1993. Battery. Possession of a firearm. Infractions. Misdemeanor driving under the influence. Felony possessing of a firearm or electronic weapons or devices or concealed weapon. Damn. And then here's a opium or delivery, sale, manufacturing. So, thank you so much, Timothy Brad, for the sticker. I like to stay focused on one case at a time. Let me just see here. Motion will the YouTube user commented be questioned. I don't know. Thank you so much for your sticker. So, delivery, possession of a firearm, burglary as well. And apparently the burglary day started from when he was already young, like a teenager. And a person who emailed me who knew Sean at a time, Sean Finnegan, I'm saying Sean as if like, who knew Sean? Sean Finnegan, the defendant, right? Said that they grew up very, very poor. And so he would resort sometimes to stealing things, you know? So the burglary could be part of that. Here it says theft or to deprive, burglary, and then it says structure or convey unoccupied, theft, burglary. This is all now from 1986, as you see. 1986, 1987, 1986. Theft or to deprive. So he was already committing crimes when Jennifer Paxton, the victim in this trial, in this case, was only like 2 years old. She was born in 1984. My goodness. This guy was already committing crimes all over Florida. Wow. Okay, let me just see what you guys are saying. Okay. Yeah, plant lady's like, what happened to three? It's 3 strikes. You're out. Shaking my damn head. Okay, so he's got many. This rap sheet is long, right? 3rd degree felony, grand theft, $300 or less, and then criminal infraction, 3rd degree felony, burglary, unoccupied structure. We just keep going on. We just keep going. Caroline White said, Grizzly, Kitty, KFC, and crochet. Nice. Chat, happy place. Thank you for being a member for 13 months. Okay, so we've got that. By the way, if you guys are... Wait. Let me put up a little title here. Court is on lunch break. Let's go. Court is on... Sorry for the typing. It's probably quite loud for you. Until 1:15 Eastern. Okay, 1:15 Eastern time. And right now it is 12:21. So we've got time to talk now because we can't defluff and we don't like it. We like to start later so we could skip over these breaks, right? Yeah, but Butterfly Dennis says, no rehabilitating SF. He is a career criminal. Yeah, Rob says, quite the rap sheet. Loba said in the defense saying yesterday, he's a very responsible, caring man. Do you remember that moment where the defense attorney is like, stand up, stand up? And the way Sean Finnegan stood up and he put his chest out like, yes, he looked at the jury like, I am an outstanding citizen. That was quite a moment, hey. I was like, oh, wow, do you think you're convincing people? It reminded me, I didn't cover Alec Murdaugh's trial. If he has a retrial, I might cover that, you know, at the time. But I didn't cover it at the time. But do you remember when Alec Murdaugh, the attorney also made him stand up? Stand up. I am honored to defend this man or represent this man or whatever. It looked a little bit like that, right? Like, oh, my word. Okay, so that's all of that. And then I think the rest, it's just like addresses and things. So I don't really want to, we could see like he's got lots of cars. A Buick, we could go, I'm just going to scroll over. There's a Buick, a Chevy, all kinds. I don't want to put anyone else's address and things up, you see, so I don't want to show all of this. But look at all of, it's just like these are now addresses and things. We've gone over the charges, right? Let's just see what else it is. Yeah, that's pretty much it. But wow. Okay, so we've got that. Now I'm going to show you something. Just hold on 1 second. Rexy, whoa, you've been a member for 24 months. Oh my goodness. You say, I love this community. Thank you so much. Damn. Okay. My channel's only 3 years old, so that's amazing. Silly Pick, thank you for being a member for 13 months. And you say Grizzly for life. Oh, thank you so much. Julie's like, so he's innocent or proven guilty? Seriously? Please, he's guilty of all charges, this monster. Yeah, this one is a difficult one to say, hey. So, okay, let me quickly fetch this picture now that where's it? I just downloaded it. Where did it go? Sis. Hold on. Email, please. Hello. Can you, not to my drive, just download it. There we go. Download the image. You can see how I speak to my computer. I download the freaking image now. Where is it? Where does it go? It doesn't want to. It doesn't like it. Okay, well, I'm going to have to take a screenshot then. Don't worry, there's always a way. If my screen goes darker for a moment, just hold on. Okay, we've got that one, and we can also screenshot this one. Here we go. I don't know if it's a different format of a file or what. Okay, so browse, here we go. Yeah, Pinky Pops says the jury won't know about his rap sheet until after. Can you imagine being on the jury and then doing research afterwards, like what someone got up to, right? Mr. Crime Buff says, this is an amazing community. I love this community. Okay, let's see if this is good. Okay, that's quite small, so let's make it like that. Okay, so thank you to the person who sent me this little local news clipping. That's cool. So it says, man arrested in November burglary. A Deerfield beach man who police said stole $80 in quarters from a restaurant last month was arrested Thursday. Sean Finnegan, 18, of the 1400 block of Southeast 2nd Avenue, was charged with burglary and petty theft in the November 20th burglary, police said. Finnegan had broken a window to get into Dirty Harry's Raw Bar. Look how they spell the name. Dirty Harry's Raw Bar. I wonder if Dirty Harry's is still there. Are they there? Tara says, love your style, GK. Oh, thank you so much. And thanks for being a member for 16 months. Okay. CRISPR, where are you from? Right? So, okay. Dirty Harry's Raw Bar at Federal 845 South Federal Highway, police said, and had taken quarters from several coin-operated games in the restaurant. Police said Finnegan had been employed at the bar until early November. I just want to see if the person who emailed said where it's from. Okay, July 4th. Oh, on July 4th of 1992, he married a lady. I'm not going to say her name here. In Broward County, Florida. So he got married in 1992. They divorced on May 3rd of 1996. Okay. Wow. Interesting. And that one's name is not one we've heard. So we haven't heard her name in this trial, okay? So yeah, he was stealing quarters. I think it was he 18? What did they say? Finnegan broke, okay, did they say his age here? No. Anyway, it was when he was younger. Police said Finnegan had been employed at the bar until early November. So it's like whenever that was, he was working there. Sean Finnegan, 18. It does say it there. So he was 18 years old and working at a bar and stealing quarters. I don't know what else he did. But at 52 years old, he was working at a bar and kidnapping and then essaying and then murdering someone. Like, what the hell? Stefan said, Dirty Harry would have said, Finnegan, go ahead and make my day. Right. So Maximo says, I wonder whatever happened to the place of employment, the Pine House, for this monster, I assume, has been a victim of this tragedy. Actually, people send me some, I must actually find that article as well. I get a lot of emails, so good luck for me finding that one. But a few people, probably, when I say a lot in this round, it will probably be like 10 people send me a link of that Pine House reopening because it closed down for a bit during COVID. And then they said it's reopened again. And just recently, a bodyguard was shot there. As in last week, a bodyguard was shot there. Like, oh my goodness. Okay, so let me fetch the other image. Hold on 1 second. I don't know if we'll be able to read it. Actually, it's quite tiny, this writing, but we're going to try. Look at this writing. Arrest made in kidnapping, in RAP and kidnapping. Authorities arrested a Blount County man they said kidnapped a Knoxville woman, held her at his home, and repeatedly RAP'd, essayed her. Right? Okay, repeatedly essayed her over 2 days before she escaped and called for help this week, officials said. This was in 2015. And Sean Shannon Finnegan, 47, of Louisville, was being held at the Blount County Jail in lieu of a $150,000 bond Friday on charges of aggravated RAPE and especially aggravated kidnapping. Knoxville Police Department personnel called Blount County Sheriff's Office officials Wednesday after a 30-year-old Knoxville woman called 911 dispatchers to report that Finnegan kidnapped her from Knoxville on Monday, held her at his Reed Road residence, and repeatedly RAPED'd her, essayed her, and assaulted her, according to a Blount County Sheriff's Office news release. The woman told police she was able to escape Wednesday when Finnegan took her back to Knoxville with the understanding that they were going to pick up her 11-year-old daughter, authorities said. The woman ran from his vehicle in Knoxville and called police, officials said. Oh, yeah. Wow, okay. So that did happen. It's not just like, oh, maybe it happened. It happened. He was charged. But like, how much time did he spend in prison and why so little? The only answer I've gotten so far is not much time, right? Deborah's like, court on a Saturday? Really? Yeah. With a sequestered jury in a death penalty trial? Mm-hmm. Yes, really. Court on a Saturday. Can you believe it? Here we are. Doesn't feel like Saturday, right? Okay, so the woman ran from his vehicle in Knoxville and called police, officials said. Blount County deputies and Knoxville police officers went to Finnegan's home in Louisville and found him walking a short distance from his residence and took him into custody. Deputies searched Reed's home and vehicle and found evidence consistent with the woman's statement. I would only assume, I'm speculating, that there were probably chains and collars and all of that. So if the jury could have known about this, that would be great. But they don't, right? Okay, I think I'm missing a lot of your comments. Quickly, let's see. Thank you so much. Robin says, Pernille, you rocked on the translation yesterday. In this trial, I live in Vegas. Appreciate your effort. Yesterday was awesome. Pernille and Kathleen and a whole bunch of Grizzlies were just like helping us transcribe what was being said in that police interview. Mostly what I heard is, I didn't do it, I didn't do it, I didn't do it. That's what Sean Finnegan said over and over and over, right? But he also said a bunch of other stuff, which thankfully those excellent ears picked up, right? Stella says, hope Mr. Grizzly doesn't miss you too much, G. We are grateful for your time. Justice for Jennifer. I really hope there will be full justice for Jennifer. Mr. Grizzly is fine. He works very hard, as much as me. Weekends, like, also probably 6-7 days a week. He's a software engineer, so we both workaholics. We suit each other. Wave in passing. Hello. Back to work we go. Okay, so he did say that he'll help me today with verdict watch if I need a nap. So that's very sweet. Very, very sweet, because I went swimming today, swimming training, and sure, that was tiring. So he's like, if you need a nap, I will be on verdict watch. I'm like, that is so sweet. Okay, so, oh, sorry, not that image. I want to take away this image. All right. So we've looked at that. Now let me see if I could find something else for you. 1 second, please. I'm going to read this again. The background. Keeping my source anonymous, of course, to respect their privacy. So I'm just going to move myself over so that I'm more like in the middle of the screen. How about that? Okay. Pernille's like, Mr. Grizzly is just as busy. Yes, if not busier. Yes, indeed. Okay. So I always ask people if they have any insight to share, any information they want to share. I always keep my sources anonymous. And if they don't want me to share something publicly, they could just let me know. Okay. And so I've gotten a bunch of emails telling us a little bit about Rebecca from high school, a little bit about Sean Finnegan, right? So actually, let me first read the one about Rebecca, because we already started reading the other one before. Okay, let me just put this court feed on so we can monitor it. Let me see the time. 12:31. We've got 45 minutes until they come back. Okay. So just hold on 1 second. I just want to get the email. That's what I was doing. Don't get distracted now. I'm like, what are we doing, guys? Okay. So somebody emailed that said, although I went to high school with Rebecca Dishman, I did not have any classes with her. We had maybe 1 or 2 mutual friends. I mean, that wouldn't also be that long ago, because Rebecca Dishman, she's 26 now, right? Yeah. Okay. Maya's like, software engineer, you're not a pilot anymore. He has a private pilot's license in South Africa, just like I have a pilot's license in South Africa, which has all lapsed. Both of ours have expired. We're no longer pilots. We haven't been for 12 years. No. He's a software engineer, and I'm a YouTuber. Can you believe it? Life can change, huh? So, and I like our life now a lot more. Okay, yes. So, now, we had maybe 1 or 2 mutual friends. From what I can recall of her from school, she was a furry online. Okay? You guys know what that is, right? Oh, no. Do I have to Google that? Oh, no. So that I can explain it nicely. The furry fandom is a subculture interested in anthropomorphic animal characters. Some examples include exhibiting human intelligence, facial expressions, speaking, walking on 2 legs, wearing costumes and things like that. That's right, Copper Horse. I am a YouTuber. A known YouTuber. If you are part of the member streams, you'll know why I say that. In Switzerland, sometimes they're like, oh, like if I go to the doctor or the bank, whatever, they're like, oh, you're a known YouTuber. When they ask how many subscribers, they're like 320,000. Oh, a known YouTuber. So thank you all for being here. If you haven't yet subscribed, please do subscribe. Okay, become part of this community. So, do we understand what furries are? I mean, we've heard so many bad words in this trial. I don't really want to go into that right now. I'm not shaming it. I'm not shaming it or shading it. I'm thinking of the context of Rebecca Dishman and what her kinks later became, right? Okay, so she was a furry online. She also always had a partner of some kind, whether male or female. Now, I find that interesting because on the stand, did Rebecca not say that she's never been with any other females until she met Sean? That's kind of what she implied. But it sounds like she was bisexual always. You know what I mean? Like, so why? I don't know why she said that on the stand. Because they say she was always had a partner of some kind, whether male or female. She was always very quiet. Her voice was monotone, as was shown in the trial footage. When news came out about this case and her involvement, many of my classmates, myself included, were not very surprised. We were shocked that someone from our class was involved in something so heinous, but not surprised it was her. So that's interesting as well. They're like, oh my word, someone from our class is involved. Oh, it's her. Okay, that's not a shock. That's quite hectic, right? Oh no. Hypnotized Lobster says there are a lot of conspiracy theories about furries. I can't. They are gross. Let's move on. Thankfully, I have not been down that rabbit hole. I don't want to go down there. You're like, let's move on. I'm shading it. Okay, so I don't know too much about it. I've just never been down the rabbit hole. Just know a little bit. Just enough to be able to just say, oh, that's what that is. Okay. They said, I do vaguely recall that there was some sort of food drive and donations for her when her parents passed away in our senior year. We did not get any information about her living situation. From what I understand from other classmates who were associated with her when her parents were alive, it was not a very good living situation for her. I believe her parents were verbally abusive towards her while living. I know that this information isn't much, but I hope it helps. It helps so much. Thank you so much to the person who sent me that. I really, really appreciate that. It's always great to have insight, you know? Loba says, sorry, but I don't know what's a furry. I'm not an English speaker. People who wear like animal costumes, I guess. I think I'm explaining it right. I don't know. They wear like animal costumes and sometimes integrate that into their sex life. I think that's what furries are. Okay, yeah, Nature Girl's like, I have to Google it and good luck because then Uncle Google will be like, oh, are you interested in that? And the next minute we'll integrate with YouTube and show you things. They all work together now. Okay, so next, let me just see some of your comments. Oh, you say Mr. G sounds so sweet. He is sweet. Nikki Lewis, thank you for being a member for 15 months. Let me just quickly read some of your comments and then I'll read the next few emails as well. And I'm monitoring the time. We've still got about 40 minutes to go. Okay, so AC says, well, it's actually a person who has a fursona. It's not always sexual. Mostly it's not. It's near to cosplay. Okay, interesting. I feel like, yeah. See, Roxanne says furries are people dressing in animal costumes doing you know what. Interesting. Okay. Yeah, Heidi's like, yet the prosecutor said she couldn't lie. I object. I think she can. Okay. I just want to see what you guys are saying, and then I'm going to read the next email. Okay, so let's go to the next one. So this email I had started reading earlier, so if it's a bit of a repeat, sorry about that. Just skip forward a little bit. So as I say, I always ask people, just send me anything you know about these people, because it's always interesting to hear a bit of backstory, right? If you've read any of my books, which are very much like my presentations, very much like written like a manual, like bullet points, you know. So I wrote 4 books in true crime about Jeffrey Dahmer, John Wayne Gacy, Eileen Wuornos, and Ted Bundy, right? And so in that as well, my favorite chapter to write was always the one about the background. Like, what was their childhood like? What was their background like? Were there any red flags? Were there signs, right? Okay, so this person said that they are, I don't know if I want to say what exactly they are, how they knew him, right? Via his sister, okay? The family has had tragedy throughout their entire lives. This is now Sean Finnegan's family, because I want to know more about that, right? There's a lot of stories. I can tell you about the background. It's horrible and tragic and sick. If you like more info, contact me. So I did. So I just said, can you just like send me some bullet points? So then they said, there's so much to say. I don't know where to begin. Just get it going. Get those bullet points going, right? So they said, I'm just being careful. Hold on 1 second. Just trying to give you aspects of this whole family. The whole family was disturbed. Interesting. It was 4 brothers, 1 sister. The father was a drifter. Left the family when the kids were young. Frances Finnegan raised them as best that she could. They were in poverty all their lives. So it's like single mom. 4 brothers, 1 sister. 5 children, single mom. My word. Frances Finnegan must have worked very hard. Aya vamos. Nice to see you again. Thank you for being a member. Yeah, for 11 months. You're like almost 1 year. That is so awesome. My goodness. Okay. Mrs. Miller says, be careful what you Google. It might pop up on your work computer while working. Oh, no. No one wants that. At least on my work computer that's right here with you guys. It can pop up. Okay, it can pop up. It's for research. Okay, so Stella, Soul, thank you so much. Really appreciate that. Sorry if I'm missing any of your comments now. Okay, so they said his oldest brother, Sean Finnegan's oldest brother, is also serving life in prison for a murder in Florida about 30 years ago when he killed his neighbor while he was on drugs. The only really surviving members of this whole family is, and he says there's a bit of a typo there, but I think it's like, I think it's this person's niece and nephew, right? Ooh, Kathleen R. says, you're definitely a lighthouse. Oh, thank you so much. If you guys don't know what this reference is, yesterday the judge shared a story of comparing being a tank and being a lighthouse, and that he always strives to be the lighthouse. So go and check that out. It's timestamped for you on day 4 of the trial. Thanks for being a member for 20 months. So then, before I get there, thank you for your $20 sticker. You said justice will prevail for Jennifer. Goodness always triumphant over evil. Gloryfulness is the light through the darkness. Oh, thank you. Thank you so much. Really appreciate that. So they said also his other brother, the younger one, just died in Tennessee about 2 weeks ago. And then they said from cancer from drinking liver. So I don't know if it was like liver cancer or like liver cirrhosis or cancer of the liver from abusing alcohol is what I'm trying to, I think that's what that means. He just passed away. Then he said, my brother-in-law died years ago when he was married to my sister. I'm trying to like picture all of this. Now, so this was one of the other brothers of Sean Finnegan died. He was hit by a bus and killed in Fort Lauderdale, Florida. And then he said, what this person said, the list just goes on and on and on. I can only imagine. I wish we knew everything, right? Oh, my word. Susan's like, charming family. So if there's Sean Finnegan and he's got 3 brothers, 1 is serving life in prison for a murder he committed in Florida 30 years ago. 1 has just died of liver cancer or died of cancer. Then his sister also passed away. And Sean Finnegan's mother also passed away. After Sean Finnegan was arrested, he said that, the police said, I think, that the mother, Frances Finnegan, moved in with her daughter, and then both the mother and the daughter died. So I think there's only 1 brother left. Oh, now they say his youngest sister. But if there's 4 brothers and 1 sister. Okay, his younger sister also died of cancer at a very young age in Tennessee. So that must be after the arrest. That must have been like 3 years ago, right? Younger sister also died of cancer. So 1 brother and 1 sister died of cancer. The other brother is in Florida, life in prison, LWOP. And his mother died. Sean Finnegan is here at this trial, of course. This is a death penalty trial. He's probably also going to, if he's found guilty, LWOP or the death penalty. And so there should be 1 brother left, right? Okay, hold on 1 second. Ooh, this one was interesting. And I hope I hope the police have investigated this. I'm sure they have, but I really hope so, right? Rob's like, the Finnegan family tree does not fork. Jinxie said, such a sad life for all these people. Casey said, poor mom worked hard for those kinds of kids. Shame. Yeah, it sounds like she worked hard. Sam's mom said, selling mom's meds. Probably. And they said Rebecca was, well, actually, Sean Finnegan said Rebecca was stealing his mother's medication. Wow. Michael Green says, where is his daughter? I don't know. Someone had emailed to say they think that she was in the care of CPS, but she must be an adult now. You know, I don't know. Because that was decades ago. Okay, so this person who emailed said, I also contacted the Tennessee detective about this case way back before this incident and told them what my niece stated he said. He said, Sean Finnegan said, according to this email, take it with a grain of salt, okay? Okay, apparently, Sean Finnegan said there were bodies buried in the backyard. The mother, Frances, was a very wonderful, nice lady. Sad, tragic, poor life that she was stuck with. I don't think she knew what was going on the whole time. I knew she was sick, very ill at the time. They say the only thing we don't understand from our side is we don't know what happened to her. We think she moved in with a daughter who was living in Tennessee, but then also passed away, and so did the daughter. I mean, that's quite hectic, right? Roxanne says, what year did this happen? So when you say this, because we talk about so many things, do you mean like this crime for this trial? It happened in 2019. December of 2019 is when the murder took place. And then Jennifer Paxton's body was found in August of 2020 under Sean Finnegan's bed after he had quickly removed it from the freezer, him anticipating the police were on the way. And he was right. The police were on the way. Yes. Okay. So that's what they say there. So like wherever that was, if he's saying there's bodies in the backyard, wherever he's lived, I hope they dig up that backyard. If anyone lives at a property where he previously lived, if you just do a background check in the USA, I know you guys have Truth Finder and all sorts of things like that. If you live at that address, dig up the backyard. AC's like, who had bodies buried? So so just remember, take it with a grain of salt, okay? I'm just reading out an email that I received. And the person is saying that Sean Finnegan told another family member that there were bodies buried in the backyard. So, yeah, what backyard? Don't know which address either. Was it the address right there? I don't know. So, let's see if there's any more. Okay. They said their father, because I wanted to know about Sean Finnegan's father. Like, what was the father like? Where's the father? Okay. Their father was a total drifter, a thief, and a drunk. I had so someone struggling with alcohol abuse, right? I had a confrontation with him the day that his son married my sister at their wedding in Florida. And the night of the wedding, when they came home, the father was staying with them because he was a drifter. He stole all their wedding gifts. What? So the dad was like a drifter, he says, a drifter, a thief, and struggled with alcohol abuse. Okay. And then he actually attended this wedding, one of the weddings. It sounds like one of the Sean Finnegan's sister's wedding. So the father attends the wedding and then stole all the wedding gifts. Imagine that. Oh my goodness. They said money, cash. So money, cash. So that's the same thing. And other items. I went out looking for him. I found him in Florida by a railroad station. And I confronted him. He took off running. He jumped on a train where there's cargo trains that are going through and disappeared into the night. That sounds like a movie. Oh my goodness. Wow. Okay. So we've got that. Just hold on one second. I'm just careful with what I'm reading out here. Just hold on one second. Okay. So I think in this next part, because he wrote many emails, I'm reading many emails, just in case you're wondering, what am I looking at? I'm looking at my email. I don't want to pull it up here in case I put something here that I shouldn't. Okay. So they talk about Sean Finnegan. He was a good man at one time. He had a very successful business. He started out with nothing. Family helped him open a pizzeria. Okay. They had a beautiful home. So I think this is actually Sean Finnegan's brother. Let's start again. So Sean Finnegan has 3 brothers. One of the brothers was apparently a nice man at the time. He got married and had 2 beautiful children. Sean Finnegan's brother. The marriage deteriorated because of drugs and it got terribly bad. And I think he was very sick at the time. He lost everything in the house. They got divorced. Then he moved in with Frances and a run-down flop. So I guess the business flopped, right? Okay. Then they said, we don't know if he was high or drunk, but he walked in front of a bus and a bus hit him and killed him. And people said that he did it intentionally, like he wanted to take his own life. Interesting. So this is Sean Finnegan's alleged brother that we're talking about. Again, all alleged because it's based on an email. I don't know exactly, how to vet the source, but it sounds legit to me. It sounds very interesting, and I'm very appreciative of any insight in emails, right? Okay. Especially in these long breaks. Oh, my word. Is it not keeping us, our minds active? My word. It's just like, wait, what? It's interesting reading it again as well. So one of Sean Finnegan's brothers apparently was killed by walking in front of a bus, and he got hit by a bus. Can you believe it? Hit by a bus. Oh, my word. Okay. And so they said, he knew something was wrong with him. He was going to die, and they had no money from the funeral. This guy that emailed said, I literally paid for the funeral. Wow. And they said the siblings all showed up to that funeral. And then he said, I'm telling you, you can make a block out of this or a movie. And I believe him. Based on all of that, with just the few things that were said in that email, I'm like, damn, this does sound like a movie. It sounds like a whole movie, right? Oh my goodness. Okay. So another thing I want to show you. I'll show you this obituary, which is here. Thank you to everyone who's sending me this as well. All right, so we can go here. Right. Yeah, Joe Ellie says, sounds very painful. So then, okay. Jennifer Gail Paxton. This is from, I'll put the link in the description box. Jennifer Gail Paxton, age 36 of Knoxville, passed away on Thursday. Well, she didn't pass away on Thursday, August 6th, but that's when they found her body, right? That's when they knew that she was no longer alive. After months of searching for her, they'd, listed her as a missing person. They'd reported to the police that she was missing. And that was about in February, I think they said, of 2020. Okay, her whole family was looking for her. Preceded in death by maternal grandfather, William Cordy, brother, Paul Dinwiddie, and uncle, Bill Cordy. Survivors are these children, which is why I said there's several, but there's 7. So they've listed the children's names here. Mother, Patricia Dinwiddie. Survivors, but her mother since passed away. Brother, I think, right? Brother, Tim, Samantha Dinwiddie. Grandmother, the family will receive friends from 12 to noon, Saturday, August 15th. So that's when the funeral was, Saturday, August 15th, at the Minot Funeral Home, Fountain City Chapel, followed by 2 p.m. funeral service. So that's what happened then, okay? If anyone's wondering what's happening, the court is on a lunch break until 1:15 EST. And so instead of just, I don't know, playing music or something, unless you guys prefer that, maybe someone's like, shut up, kids, let's just play music. I've got music. If you want music and you just want break time music like we did for the first trial that I covered, that was the Letitia Stout trial, I do have that. But I like talking to you. And we've only got about 20 minutes left or so. 25 or so. Okay. Ellie B from Tennessee said, let's put purple hearts in chat for Jennifer. Jennifer Paxton's favorite color was purple. So that's why we share purple hearts. I actually don't have my necklace on today. Sorry. But yes, please share purple hearts in chat for Jennifer. Oh, thank you so much, DMH2000. That's a sweet comment. Thank you very much. So now if you go down here, you can see they say, hello, Paxton family. Please forgive me, but I'm just now getting acquainted with the loss of your precious Jennifer. My wife and I send our warmest, sincerest regards for your loss. May God strengthen your hearts during this immense trial and difficulty in your lives. That is so sweet. And they said, words can't express how sorry I am this happened to you, Jennifer. I have some comfort knowing you're in heaven now with your big brother, and you'll never be hurt again. Please watch down over me, Kylie and your brother. Rest in peace until we meet again. That was in 2020. And here they said, rest in peace, my beautiful, sweet cousin. You'll be missed, and you are always in our hearts. I'm so sorry for your loss, Aunt Patty, Timmy, and all our family affected by Jen's passing. Love always, Heather, Daniel, and Matthew. And here they said, so sorry, Patty and Timmy and the rest of the family for the tragic loss of such a sweet woman. Love you all. A lot of families described her as extremely sweet, loved to make people laugh. Shame, man. Tama says, love to sweet Jennifer and her children. Thank you for the purple hearts. Kimberly's like, we like it when you talk to us. Okay, good. Oh, thank you so much. Okay. Yeah, like that is sweet. Sarah says, that is sweet. Okay. Kimberly says, we can listen to music anytime. Yes, true, good point. So, Michael and Melissa Pack here said, prayers and love, Patty. I'm so sorry for your loss. Stay strong, and I know that she's at peace now. Though I hadn't seen her in a number of years, I always thought the world of Jennifer. I'm so sorry for your loss. J-Man. Jason Nichols wrote, Patty, my heart aches for you and Timmy. I know no words, but I know who does. And then they've got a whole bunch of Bible verses here for them. They said, the only peace in this tragedy is God. Only he can heal you. Lean on him when you cannot stand alone. Love you always. And Michelle said, Patty, I'm so sorry for your loss. Sorry, those are pictures of the children. My prayers are with each of the family. God be with you during this time. Now, let me quickly just fetch some of these pictures. Hold on 1 second. I don't want to show the children, but I do want to show some of Jennifer. So just hold on. I'm getting there. There's quite a few of them. Here's one. Shame. Okay. There's lots of pictures here. So I'll put this in the description box. I think this was, I think this is Jennifer. And I think this is her brother. Maybe her brothers, right? Shame, man. She was so sweet. Oh my goodness. Okay, wait. Yeah. Can I show that? Okay. I think this was when one of her babies was born. I'm assuming. There she is as well. Right? Okay. I'm just taking the pictures off the screen here and there to protect the children, okay? And there she is as well. Look at her. My goodness. Shame. Such a nice picture when she was younger. Lacey said, did his girlfriend get arrested? Do you mean Sean Finnegan's girlfriend? She pleaded guilty. She got life in prison plus 50 years. So yes, she did. She got arrested. Both of them got arrested on August 6th of 2020. And she already pleaded guilty in September. So, and she had to testify against him. Okay. Let's go to another one. Here's another one of her when she was younger. Sweet. This is the bunny, right? Cute. Okay. Got that one. I can't see what picture's next, so I'd rather take it off the screen. Let me just actually page through 3 of them or so. See, I could maybe show 2 of these. Okay. You can go see it. I'll put the link in the description box. I just don't like to just like show children on the internet. Never a safe thing to do. Okay. So, here's a picture of her as well. Oh, shame. And this little baby. Okay. So let's take that one off. And then let's just quickly go find some more here. Hold on. Nope. Those are of her kids. Okay. I think that was all of them. So I will link this for you if you want to go and see more of the pictures yourself as well. Okay, so we've got that. Now we need some water. And I'm going to be like the judge. I'm going to sip some water now, everyone. I'm feeling thirsty. Okay, so now let me ask you, who do you think the most, and it's not like a game of favorites, so I'm just wondering, who for you was the most impactful witness throughout this trial? Like what stuck in your memory, right? I think it's probably it's probably a rhetorical question, isn't it? But let me know. I want to see what you say. Yeah, so Angel says, addiction is such a sad situation. It destroys the best of people. I'm so sad that she never got the chance to make her life better. Yep. That is so sad. Jinxie said, I pray her children have a good life. I hope so. Thank you, Julie, for sharing purple hearts. And Carol says so pretty she was. And Bridget said, she's so beautiful, right? Yes. Tara said, why doesn't CPS help these single moms first if they are struggling and single male parents? Are we talking about, single mom, are we talking about Sean Finnegan's mom or are we talking about Jennifer Paxton? I think CPS I think that made her really sad. They said when Jennifer Paxton lost her children and they were, taken into the care of CPS. That really, really impacted her life, and she was extremely upset about it. And she went to go and live in a tent in the woods, and she was struggling with addiction. And Sean Finnegan came along. Oh my goodness. Yeah, there you go. There you go. I knew it. So I'm like, I think it's a rhetorical question, especially because all of us, like many of us, not all of us, but many of us are visual learners. So that medical examiner with the mannequin, that was very impactful. Also to show all the different types of injuries. Oh my goodness. Like there were sharp force injuries and there were blunt force injuries and just all kinds with all the different colored, little sponges and things that they put in. That was very impactful. So I think that was a testimony that's going to stick in the jurors' minds, right? I think Mahogany as well, who was the neighbor, I think her testimony was very impactful as well. Like if I were on the jury, of course, I wouldn't be because I do too much homework before the time. I'm disqualified immediately. But if I were, okay, I would just think, let's pretend I was, or we were, and we didn't know anything about the case before, and there we are, right? So now what would stick in our minds? What would make one think, could Sean Finnegan be guilty of first-degree murder? Could he be? I think, hearing about the baseball bat disappearing from work was one thing. Buying the freezer, Rebecca said before Jennifer Paxton died, that's quite something as well. The medical examiner's testimony and demonstrations, just all of that. It stays in your memory. And what Mahogany said. I think Colt was a great witness as well. That's Mahogany's husband, right? Zencat says, still bothers me that during closed defense and even the state suggested most homeless people are messed up and no one misses them when they vanish. I feel you. Some of it was painful to hear the way that they spoke about people experiencing homelessness, and I say that for a reason, not just like homeless people. I find that can be like quite a cold way to say it, right? So someone experiencing homelessness, because that's what they're experiencing. It's not like they're just like homeless people all their life. You know what I mean? So I wish that people would say, okay, they are people that experience homelessness and maybe they also struggle with addiction. And those people are very vulnerable. And this is how I would have worded it. I don't know, based on what we saw and how cold sometimes it came across. You're just like, whoa. Maybe I would have said Sean Finnegan seemed to pick on vulnerable people, which is the lowest of the low, right? Him, the lowest of the low, picking on vulnerable people. And offering and pretending to be the good guy, offering Jennifer a place to stay, saying, I will pay you this much to do a sexual favor, and then why don't you come stay? And it was over Christmas, It must have been cold as well, right? Tennessee, Christmas time, huh? What are the temperatures like? So to say, why don't you come and stay with us for a while? I would assume he'd be like, and for Christmas. And she went thinking, oh, cool, I'll have a place to stay for a little bit. And it will be, Sean said it would be, the three of them would be having sex together. But damn, to get there, have a bowl of cereal, and then be hit over the head with a baseball bat, and then chained, tortured, essayed, all of that is horrendous. So yeah, okay. Jane P said Jennifer was an easy target because she was off the map, so to speak. So yeah, a vulnerable target. I think, sorry, I didn't finish that sentence. I think what they were trying to do was explain the victimology, of the victim in this case, just some of the risk factors, but it just came across almost borderline victim blaming rather than looking at Sean Finnegan. Like it's better to look at him as the perpetrator, the defendant, the guy that's on trial and say, look what he did. He picked on someone vulnerable, someone experiencing homelessness, someone struggling with addiction, someone who had lost her children. She was depressed. And he picked on that person by offering her something. And then, in the end, just absolutely brutalized her. That would be a good way to explain that, right? To make the impact. So the jury understands there. Yeah, Carol says, when all the time he knew. Johnny Desant said, monster preyed on the vulnerable. Actually, you had a good quote yesterday, Johnny. What was it? I put it on the screen. I was just like, that is a good quote. Yes. Okay, so Mrs. Melissa said, I know some homeless people have trouble getting jobs because they don't have ID, social security card, proof of who they are. Really sad. Can't get a job or housing. That is sad. Okay. Placer 1000 said, he's guilty. I wouldn't need the jury room. I wonder how many people of the jury, because there's 16, right? Including 4 alternates. And if you didn't know yet, there's 8 females and 8 males. Okay. So the judge said he's going to take his coffee cup, pull out 4 of the numbers. Okay. And those will be the alternates. And then 12 people will go off to deliberate. When they come back, then the judge is going to finish reading the jury instructions with that gigantic pile of papers there. I thought he was just about done with it, but he's like, we need a lunch break. And I suppose the jury would also need a lunch break. You know, he's just like, oh, okay, let's just have a break, come back. Also, that makes sense. It's actually quite clever. The judge is like, have a lunch break now. When he comes back, then he continues the jury instructions, and then they'll go off to deliberate. Because most of the time, when we watch trials together, as soon as they go off to deliberate, it's like noonish or one-ish, and we're like, oh, they're probably eating lunch first. So the clock starts, but and they might be talking about things. Maybe they are deliberating, but they're like, oh, they're probably eating lunch. Right? So, okay, we only got like 12 minutes to go. Quite nice. And then the judge will be back. So, what was the point? Oh, yeah. Imagine if 12 of them get in the room. 8 of them like, guilty, right? Guilty. And the other 4 maybe not. Who knows? I don't know. Because some people in this chat, just based on what people say, no, he's guilty. Wouldn't need the jury room. Interesting. We'll do a poll later. There will be a verdict watch stream, which will become the verdict stream. So what I do is normally, once this stream is almost ready to finish, after the judge is finished with everything that he's doing, let me actually put that stream just back on so I can monitor it. Okay, good. We're monitoring it. Then we'll be teleported or redirected to the verdict watch stream. Later, that thumbnail will say verdict, and so will the title. For now, it's just verdict watch. I can't call it verdict because people will think there's a verdict already. There isn't one. It's verdict watch. We'll go over there, and then maybe there later I could put up a poll of what you think. It's just difficult to say, what do you think the jury's, what do you think it will be, guilty, not guilty, or that, because so many charges. I mean, it might be guilty on some and not guilty on others, or lesser charges on others. I think it's going to take some time, right? Okay. Hello to Guilty of Crime. Sorry, I think I put your comment on screen there, but I didn't even say hello. Hello to you. Okay. Lacey's like, I don't think I could do jury service. Oh, man. Oh, my word. Kraken says, can you imagine being sequestered and having your number pulled up as an alternate and being sent home? Imagine. And the 4 alternates have to go and sit in a separate room the whole time. Well, that's what they said. They don't want to send any of them home. They're going to be sitting in a room, reading books or entertaining themselves, not talking to each other the entire time that the other 12 are deliberating. Honey Bunny said, unfortunately, monsters like this look for marginalized people who they think won't be missed. See, that's a good way to word that. I think that's what the state was trying to say. This is a good way to word that. I think so. I mean, we see it with cases like Rex Heuermann, who's also innocent until proven guilty, but you know what I mean. The Long Island serial killer case, we see that as well, right? Oh, Ellie B from Tennessee said, Molly says she knew Sean well and emailed you. When? Where? I'm looking. Oh, okay. I see one. Okay, let's see. Okay, let me just quickly read what they said here. Okay. I'm not understanding. Wait. You were okay. This person, Molly. I just want to see. Normally I keep my sources anonymous, but Molly, you're saying check it. Okay, so everyone's saying check it. Thank you for the email, Molly. You said not necessarily obvious that he was off, but apparently my instincts knew better than myself did. So you said, crazy. They left my brother almost completely out of it. He was there. Oh, your brother is who Rebecca used to get giddy about. Interesting. That's whose car was being used? Okay. You said, Molly, that your kids were being babysat there for a while at Mahogany's. So not with Sean Finnegan and Rebecca, right? Because that's scary. And you said also, I worked with Finn, and I'm thankful I never went over by myself. Right? Okay. Thank you. Thank you for your email. I'll look at that later. Again, I see there's some screenshots. I just want to, before I just read things out, I just want to check it out later. Maybe if there's anything interesting there, I will have a look at it at the verdict watch one. Okay, so Gracie, thank you for the purple hearts. All right. Nice, Tina, lurking as I make curry. Nice. Thank you for being here. Thank you all for being here on a Saturday. If you are confused, if you're just joining now, like, why is there court on a Saturday? The jury is sequestered the entire time. This is a two-phase trial because it's a death penalty trial. And so they did anticipate that they said on the jury would probably have to work on Saturday. It's actually been amazingly on time with the schedule. Because imagine if they went overtime, then what? Do they work on Saturday, come back on Monday? I don't know. Anyway, so now today they are working. They'll be deliberating after the judge is finished with all his jury instructions. Lobo Volcano said, celebrating with you the Fair of the Virgin of La Paloma, or La Verbena de la Paloma, main festivity of Madrid. Oh, thank you for taking us with you. Thank you so much. Okay. Barbara says, gee, I sit in doctor's offices. I'm the only one not looking at a cell phone. Even the kids, no one reads a book unless it's on their phone. I know, right? And I like books. I also like the paper, and I know save the trees and all that, but I also like save your eyes as well, right? Reading books, I love reading books as well. I wish I had more time to do that. Yes. Stella Soul says, I wish, you say I could be on that jury. Cuff him. Cuff him now. Okay, let's see the time quickly. We're actually doing pretty well with time. 7 minutes, and then they should be back. Let's hope they're not late, because that will not be nice. Okay. All right. So, any questions? I didn't actually see what you all said to who was the most memorable witness. I would say the medical examiner was brilliant. I think Mahogany was really good. Of course, Rebecca was very impactful. It just depends on if the jury believes her or not. I think she was believable. There might be a few little lies in there. I don't know. But I think she said it as it is. She's got nothing to lose. There's nothing to lose and nothing to gain. She's already pleaded guilty, life plus 50 years. So I think her testimony was memorable in a different kind of way than the medical examiner. That was quite something, right? Hans says, gee, what do you think of his mother alerting Sean when Rebecca fled? I do think that's quite interesting. I do think that's a very interesting one. And I wonder if it's, there's so many things we could wonder. Is it because his mother knew that he'd freak out because, she'd been through other breakups before, seen him breaking up with girls or girls leaving, women leaving, or what? Or did she just look out the window and holy crap, she's carrying all her stuff out? I don't know. Yeah, Pernille says, loved Colt's facial expressions. The med examiner was powerful. Do you guys remember Colt's facial expressions? It was just so classic. Oh my goodness. I made this short for you guys. I don't know if you saw it. So hold on 1 second. I'll bring it up for you. I'll put the sound off here for a second. Okay. And actually, while I'm here, here's my channel. Unknown. Okay, moving on. Here's my channel. A lot of people ask me, where's this community tab? A lot of people can't find it for some reason. So you see there's home, videos, shorts, live, playlists. Playlist is a good place to go because there's many trials that maybe you haven't seen and they're all timestamped for you and defluffed and all that. Playlist, right? Community. There it is. Community tab. Okay. So that's where you go, where I post lots of updates and things on cases. This was about the 2 missing Georgia firefighters that I just recently posted that update because the autopsy results came out and things like that, right? Oh my word. This case, if you guys didn't see it, please watch it. This case is so crazy. This case is that's like a movie. What was this guy doing? Anyway, so, and here's Willow for the members. So if you are a member, you might want to check out the community tab because I show pictures of the cats. Look at Willow. That's how she lies on the carpet and looks at me while I'm streaming with you guys. And it's not distracting at all. No. Anyway, I wanted to show you a short that I made, which was this one.
Male friends? Were your friends male?
Yeah.
This one.
I wouldn't call it flirtatious.
Were they male friends? Were your friends male?
Yeah, I'm married.
Okay.
Were your friends male? Yeah, I'm married. Okay, whoa, defensive. I'm going forward.
I don't know.
Watch him.
Okay. I mean, you can have friends that are girls if you're married, but they were male friends. She was flipping her hair, and
oh my word, I love this guy's face. Oh man, we were all laughing at that. That was a great moment. Adam Bluefire says, Gizla, how did Sean's mom not notice kidnapped Jennifer? A large freezer in the closet plus all their BDSM. I don't know. They said she was hard of hearing, she was elderly, she was sickly, and if I really had to speculate, I would almost lean towards like, were they like tranking her, you know, like eye drops in the tea? I don't even know. I would speculate more towards that than the mom knowing. You know what I mean? Like, how were they sedating her? Is where my mind goes. But that's just my opinion. Ellie B from Tennessee says, Willow is so beautiful. She's so beautiful, right? And my word, she's so cute. And Fury is feisty. Okay, so are we there yet? I think it's almost time. 2 minutes. Okay, wait. 2 minutes and they should be coming back. So let's put the seal on. Let's put the sound on. And when we see that shake a little bit, we know, they're coming back soon. Okay. Laura True says, I like the Picos. That was Mahogany and Colt. Yes, they were brilliant. Oh my goodness. Shame. Poor Mahogany. She got very upset on the stand as well. But some of the things she had to testify to, right? And if it wasn't for them as well, they saw something and they said something. Because Rebecca told them some crazy things. Like there's a body in the freezer. And Sean has killed someone. That's what Rebecca said, right? And so for Mahogany to call the police, that was very brave. Because she might have been like, what? Like, I don't want to get involved with that. Like, what do you mean? She called the police. Her husband also spoke to... she called her husband. She called the police. Her husband called the police. That was great. That was really great. Nature Girl says, I think Rebecca plays a good victim. Yeah, I think so a little bit too. I think that's also a role she'd like to play, you know, with Sean. No. LEB from Tennessee says, OMG, eye drops are going to end up being banned with all these cases. Yeah, those types you don't get in Europe. It is banned here, actually. You know, Visine, those ones that can be used for that we see in all these true crime cases. It shouldn't be. It should be for your eyeballs. Like, what the hell are people doing? Okay, that case I just showed you that I said you should check out is also one. It's also an eye drop poison trial that's coming up at some point. It's a case, right, of a paramedic who poisoned his wife and killed her with eye drops, allegedly. And then he's also just started doing it to his daughter. So now he was bonded out and now he's been rearrested. If you didn't see it, it's on my live stream replays, okay? Moonchild said, we don't know if he abused mom or had her living in fear, right? We don't know that as well. Psychosaurus Ray said, gee, your faith in the courtroom Thailanders is so sweet, I love it. Nothing could be worse than the Laredo, Texas, Burgos Aviles tardiness. That was so bad. But this judge has actually been very on time. He's been very good so far, right? So now, it's 15:15 now. They should be coming back soon. Okay. Julie, Carol, thanks for sharing the purple hearts. Thank you all for keeping me company. See? This judge is amazing. Thanks for keeping me company. I hope I kept you company. I hope I kept your minds active, stimulated in that break, right? Because that was a long break of probably staring at the wall. At least we didn't have to stare at the wall. We had a lot to talk about. Thank you to all the Grizzlies and anyone that's new here for emailing me. How do we say your name again? Saurus. I just remember. There's Psychosaurus Rex. I'm like, you see, there they are. Oh, not quite. False alarm. False alarm. Okay. So, yeah, Caroline said, it's too hilarious when they try to ban stuff for public safety. They must not know that damn near everything is dangerous if you decide to use it to hurt someone else. Right? Julie, thank you for the hearts as well. Okay. Thank you, Lil Miss. I love it when Grizzlies in chat answer questions. If someone's like, why is the court on a Saturday? You say the jury's sequestered, so that's why Saturday court. Esme says, are you ready? I'm ready. Are you ready? I'm ready. While we wait... Because I don't know. I don't know how to just like sit and wait. No. So let's just go over some of this again. Sure, that's Jennifer. She was 36 when she was murdered. Okay. The depraved pair. One has already pleaded guilty. That's the one on the right. Those are their mugshots, by the way, if you haven't seen them before. Hans, thank you so much. You're like, go. Thank you so much for the $20 sticker. Shannon Finnegan. You know what's interesting? Is on that Facebook screenshot, it said that Rebecca is in a relationship with Sean Michael Finnegan, so I don't know why he changed his middle name. Like online, right? Shannon Finnegan, now 56, and Rebecca Dishman, now 26, met on social media in 2019. Rebecca has pleaded guilty and will be testifying against Sean at this trial. She did already. Will she have to testify again? Are there more testimonies in the punishment phase? Huh? That'll be interesting. He's charged with, in case you didn't hear this, and I think the judge might still be reading some of these counts when he comes back, or continue with the instructions. He's charged with first-degree murder, aggravated, I'm just going to say SA for YouTube, aggravated kidnapping, abuse of a corpse, tampering with evidence in the death of Jennifer Paxton. Warning, what these two allegedly did to a 3-year-old child and another child, and to Jennifer Paxton, is horrific. Trigger warning for this whole trial, right? If you did not watch day 1, and you're like, this sounds interesting, I'm going to go back and watch day 1. Watch it, but just know. And I did at least warn you throughout that as well. It comes with a huge trigger warning. It's like quite a gruesome case. I saw someone say it's like top 10 for like the worst cases. I don't know. There's some bad cases. And obviously when I wrote those books about serial killers, you know, the things that Jeffrey Dahmer did, oh my word. What he did with bodies afterwards. Whoa. That was bad. But from what I've covered, yeah, this is one of the worst. One that I almost covered and was just like, it's just too graphic, gruesome, horrendous, was that Taylor Shea Business one. Remember that? Okay. Thank you, Donna, for being here, and I'm glad that we are helping you. I'm sorry about that. So, also, Sean's mother lived in the home the entire time this happened. I put that in my presentation before the trial started because I found that so interesting. Like, how? This is the home where it happened. I actually want to see if I have more pictures of the home. Hold on. I must have surely downloaded them. Yes. To the Grizzly, who drove out there. Thank you. I didn't ask. They offered. I actually said, no, don't worry. Stay safe. Don't drive. I don't know who's living there, if there's anyone there, but don't worry about driving past. And then they emailed and said, I couldn't help it. I went there. I went to go look. So this is the house where it happened. I think it was the one on the left. Yes. Okay.
Anything you need to do before I bring a jury in?
No.
Anything for the defense? Thank you. Have to bring a jury in.
All right.
Let's see the time. How late were they? 4 minutes. This judge is amazing. We love a punctual judge. 4 minutes late is not bad at all. Right? Cheryl says, whatever happened to Sean's mother? She passed away. She moved in with her daughter and passed away, and her daughter also passed away. Oh my goodness, right? Johnny said, didn't Rebecca dodge the DP by testifying? She did. By her plea agreement, yes, she did. Okay. Show you another picture quickly. Here's another picture of the house. Okay, jury's coming back in. Instructions continue. I actually have to go and get some
Have a seat, please.
hydration.
And back to our jury instructions. We're going to start off with the lesser included offense of count 8, which is false imprisonment. Any person who commits the offense of false imprisonment is guilty of the crime. We find the defendant guilty of this offense. The state must prove beyond a reasonable doubt the existence of the following such elements. 1, defendant removed or confined another unlawfully so as to interfere substantially with the other person's liberty. And 2, the defendant acted knowingly. A removal or confinement is unlawful. It's accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of kidnapping, you must also find a reasonable doubt that the removal of the confinement was to a greater degree than necessary to commit the offenses of premeditated first-degree murder, felony murder, or aggravated rape, discharging counts as including counts 1, 3, 4, 5, and 6. In making this determination, you may consider all the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement by the defendant. B, whether removal or confinement occurred during the commission of a separate offense. C, whether interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether removal or confinement of the alleged victim from the summoning assistance, although the defendant need not have been succeeded in preventing the alleged victim doing so. E, whether the removal or confinement reduces the defendant's risk of detection, although the defendant need not have exceeded in that objective, and F, whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that possessed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape that was not essentially incidental to it, you must find the defendant not guilty of aggravated kidnapping. The definitions of bodily injury, knowingly, intentionally have been previously defined for you in the instructions on aggravated rape. You can refer to that in these definitions herein. Fraud, violence, and force have previously been defined as well. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false imprisonment, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of false imprisonment as charged in the indictment, then your verdict will be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of attempted false imprisonment, a lesser included offense. The essential elements necessary to constitute attempt at false imprisonment have previously been set out in the instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted false imprisonment, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilty of attempted false imprisonment as the charge in the indictment, then your verdict must be not guilty as to this offense.
Ooh, there's still a lot of paper on this file. Listen, Judge, I gotta start my stopwatch again. Remember, you said he's gonna take 45 minutes. It's just a little joke now. Resume. Okay, resume. So he's continuing. For anyone just joining now, what happened was they were busy with jury instructions, and then, I mean, it's so voluminous, so lengthy, they took a lunch break, and now they're back, continuing with jury instructions. After that, the jury will go off to deliberate, and we'll be on verdict watch.
Count 9. Conspiracy to commit premeditated first-degree murder. Any person who conspires to commit premeditated first-degree murder is guilty of a crime. For you find the defendant guilty of criminal conspiracy to commit premeditated first-degree murder, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1. The defendant entered into an agreement with one or more people to commit the offense of premeditated first-degree murder. It is not necessary that the object of the agreement be attained. And 2. Each of the parties to the conspiracy had the intent to commit the offense of premeditated first-degree murder, which has been defined for you in count 1. 3. Each party acting for the purpose of promoting or facilitating the commission of the offense of premeditated first-degree murder agreed that one or more of them would engage in conduct which constitute the offense of premeditated first-degree murder. And 4. One of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here for count 9, its lesser included offense intent means a person acts intentionally when it is that person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement they be completed is abandoned by the person or by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit premeditated first-degree murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit premeditated first-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of the conspiracy to commit second-degree murder, a lesser included offense. Any person who conspires to commit second-degree murder is guilty of a crime. Were you to find the defendant guilty of criminal conspiracy to commit second-degree murder, the state must prove beyond a reasonable doubt the existence of the following essential elements. Excuse me. The defendant entered into agreement with one or more people to commit the offense of second-degree murder. It is not necessary that the object of the agreement be obtained. And 2, Each of the parties to the conspiracy had the intent to commit the offense of second-degree murder, which has been defined for you in the lesser included offenses of count 1. And 3, each party acted for the purpose of promoting and facilitating the commission of the offense of second-degree murder has agreed that one or more of them would engage in conduct which constitute the offense of second-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of that conspiracy. Here, intent means the person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they may be completed is abandoned by the person and by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime and obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit second-degree murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit second-degree murder as charged in the indictment, then your verdict will be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of conspiracy to commit voluntary manslaughter as a lesser included offense. Any person who conspires to commit voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of the criminal conspiracy to commit voluntary manslaughter, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into agreement with one or more people to commit the offense of voluntary manslaughter. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of voluntary manslaughter, which has been defined for you in the lesser included offenses of count 1. And 3, each party acted for the purpose of promoting or facilitating the commission of the offense of voluntary manslaughter, agreed that one or more of them would engage in the conduct which constitute the offense of voluntary manslaughter. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one party to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here, intent means the person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objects of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of the proceeds of the offense, and measures other than for silence for concealing the crime, obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit voluntary manslaughter, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of the conspiracy to commit voluntary manslaughter as charged in the indictment, then your verdict must be not guilty to this offense. Count 10. Conspiracy to commit aggravated rape. Any person who conspires to commit aggravated rape is guilty of a crime. For you to find the defendant guilty of criminal conspiracy to commit aggravated rape, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, defendant entered into an agreement with one or more people to commit the offense of aggravated rape. It's not necessary the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated rape, which has been defined for you in counts 4, 5, and 6. And 3, each party acted for the purpose of promoting and facilitating the commission of the offense of aggravated rape, agreed that one or more of them would engage in that conduct which constitutes the offense of aggravated rape. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards execution of the conspiracy. Here, for count 10, as lesser included offenses, intent means that a person acts with intentionally with respect to the nature of the conduct or to the result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include but are not limited to the following: escape from the offense, distribution of proceeds of the offense, measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit aggravated rape, as charged in the indictment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of facilitation of conspiracy to commit aggravated rape as a lesser offense. Any person who conspires to commit a rape is guilty of a crime. For you to find the defendant guilty of criminal conspiracy to commit rape, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, defendant entered into an agreement with one or more persons to commit the offense of rape. It's not necessary the object of that agreement be obtained or attained. 2, each of the parties to the conspiracy had the intent to commit the offense of rape, which has been defined for you in the lesser included offenses of count 4, 5, and 6. Each party acting for the purpose of promoting or facilitating the commission of rape agreed that one or more persons would engage in conduct which constitute the offense of rape. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must step toward the execution of the conspiracy. Here, for count 10 and its lesser included offenses, intent means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct, or the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they may be completed is abandoned by the person and by those whom the person conspired. The objective of the conspiracy include but are not limited to escape from offense, distribution of proceeds of the offense, measures other than silence, or consent the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit rape, as charged in the indictment, then your verdict must be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of facilitation of conspiracy to commit rape, a lesser included offense. Any person who conspires to commit aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of criminal conspiracy to commit aggravated sexual battery, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, defendant entered into an agreement with one or more people to commit the offense of aggravated sexual battery. It's not necessary that the object of that agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated sexual battery, which has been defined for you in lesser included offenses of counts 4, 5, and 6. Each party acting for the purpose of promoting and facilitating the commission of the offense of aggravated sexual battery agreed that one or more of them would engage in the conduct which constitute the offense of aggravated sexual battery. 4, one of the parties of the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards execution. Here, for count 10 and its lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or the result of the conduct once the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objective of the conspiracy are completed or the agreement that they be completed is abandoned by the persons and by those who the person has conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, measures other than silence for concealing the crime, or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit aggravated sexual battery, you will so report in your verdict form. If you have a reasonable doubt as to the defense guilty of conspiracy to commit aggravated sexual battery is charged in the indictment, then your verdict must be not guilty as this offense, and then you proceed to consider guilt or innocence of facilitation of conspiracy to commit aggravated sexual battery as a lesser offense. Any person who conspires to commit sexual battery is guilty of a crime. For you find the defendant guilty of criminal conspiracy to commit sexual battery, the state must have proven beyond a reasonable doubt the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of sexual battery. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of sexual battery, which has been defined for you in lesser included offenses of 4, 5, and 6. Each party acting for the purpose of promoting and facilitating the commission of the offense of sexual battery agreed that one or more of them would engage in conduct which constitute the offense of sexual battery. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here, for count 10, it's lesser included offenses. Intent means a person acts intentionally with respect to the nature of the conduct or to result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the object of the conspiracy is completed or the agreement that they be completed is abandoned by the person and those whom the person inspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit sexual battery, you will report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit sexual battery as charged in the indictment, then your verdict must be not guilty as to that offense. Count 11, conspiracy to commit aggravated kidnapping. Any person who conspires to commit aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of criminal conspiracy to commit aggravated kidnapping, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of aggravated kidnapping. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated kidnapping, which has been defined for you in count 7. And 3, each party acting for the purpose of promoting or facilitating the commission of offense of aggravated kidnapping agreed that one or more of them would engage in the conduct which constitutes the offense of aggravated kidnapping. One of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by those parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here for count 11, it's lesser included offenses. Intent means a person acts intentionally with respect to the nature of conduct or as a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that may be completed is abandoned by the person or those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit aggravated kidnapping, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to the offense, and then you proceed to determine its guilt or innocence of conspiracy to commit kidnapping, a lesser included offense. Conspiracy to commit kidnapping. For any person who conspires to commit kidnapping is guilty of a crime. For to find the defendant guilty of criminal conspiracy to commit kidnapping, the state must have proved beyond a reasonable doubt the existence of the following elements. 1, the defendant entered into an agreement with one or more people to commit the offense of kidnapping. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of kidnapping, which has been defined for you in the lesser included offenses of count 7. And 3, each party acting for the purpose of promoting or facilitating commission of the offense of kidnapping agreed that one or more of them would engage in the conduct which constitutes the offense of kidnapping. And 4, one of the parties to the conspiracy committed an overt act in furtherance of conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here, for count 11, as lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a
Quick pause. There's people asking if you're in the live stream now. If you're watching the replay, disregard. But if you're in the live stream right now with me, this is live right now. It's happening right now in real time on a Saturday, and these are the jury instructions. And after this, it will be time for the verdict watch. Okay, we're gonna go to another stream for that, so that you all get the notification once the verdict is in. Then when I go live, you'll get the notification, which is why I do it that way. So. We're not going to stay in this stream. We're going to listen to the jury instructions once court is finished here and the jury goes off and the cameras go off. Oh, okay. Then we're going to go wait at the next stream there for the verdict. I see on the poll you guys are voting. If you're live here with me, how long do you think the jury will deliberate for? 40% say 1 to 4 hours. 37% says 4 to 8 hours. 16% say 4 to 8 is 37%, 8 to 12 is 16%, and 12 plus hours is 6% vote so far. Keep voting.
continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that be completed as abandoned by the person and those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution for the proceeds of the offense, and measures other than the silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of the conspiracy to commit false imprisonment, a lesser included offense.
Mary says, you are hearing a true Upper East Tennessee dialect. I'm from that area and miss hearing folks from home. I like it a lot.
False imprisonment. Any person who conspires to commit false imprisonment is guilty of the crime. For you find the defendant guilty of criminal conspiracy to commit false imprisonment, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of false imprisonment. It's not necessary the object of that agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of false imprisonment, which has been defined for you in the lesser included offenses in count 7. And 3, each party acting for the purpose of promoting or facilitating the commission of the offense of false imprisonment agreed that one or more of them would engage in the conduct which constitute the offense of false imprisonment. 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of conspiracy. Here for count 11, as lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or the result of the conduct, unless the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that may be completed is abandoned by the person and by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than the silence for concealing the crime or obstructing justice in its relation If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit false imprisonment, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit false imprisonment as charged in the indictment, then your verdict must be not guilty as to this offense.
Don't knock that over now, Judge. That was close. I'm still just laughing at the fact that the judge yesterday was like, this will just take me 45 minutes to an hour. You know, he said to the jury, the instructions are about 100 pages long, but I'm a fast reader, so it'll be like an hour, maybe 45 minutes. And as I've said, I know myself, because that's how I think with documents. I'm like, 100 pages is too easy. Let's do it. And then it's like 3 hours later. Right now, the judge has been reading for over 2 hours. 2 hours and 2 minutes already. 3 hours is accurate, okay? 100 pages, probably about 3 hours. To read through it yourself, yeah, that might be an hour. But to verbalize it all, oh my word, it's so long and draining. It's just like, oh man, I just feel his pain there. I understand.
Count 12, abuse of the corpse. Any person who commits the offense of abuse of the corpse is guilty of the crime. For to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt that exists of the following essential elements. 1, the defendant did physically mistreat the corpse in a manner offensive to the sensibilities of an ordinary person. And 2, the defendant acted without legal privilege. And 3, the defendant acted knowingly. In the sign where the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective personal and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Legal privilege means a particular benefit or advantage created by law. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Here, knowingly means a person acts knowingly with respect to the conduct and the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances that exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. If you find from the proof beyond a reasonable doubt the defendant is guilty of abuse of the corpse, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of the corpse as charged in an indictment, then your verdict must be not guilty. And as to this offense, then you shall proceed to determine his guilt or innocence of attempted abuse of the corpse. Attempted abuse of the corpse. The essential elements necessary to constitute attempt and abuse of the corpse have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted abuse of the corpse, you shall so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted abuse of the corpse as charged in the indictment, then your verdict must be not guilty as to that offense, and then you should proceed to determine his guilt or innocence of facilitation of abuse of the corpse, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and abuse of the corpse have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of abuse of the corpse, you will report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of abuse of the corpse as charged in your indictment, then your verdict must be not guilty as to this offense.
Rob says, it's a Ricola time, Judge. You know from watching me reading Jesse Krzyzewski's letters and all sorts of things. Hey, with that Barry Morphew probable cause affidavit. Oh, my word.
Tampering with evidence, count 13. Any person who tampers with evidence is guilty of a crime. For to find the defendant guilty of this offense, the state must prove the essential following elements. 1. The defendant knew an investigation was pending. And 2. The defendant destroyed or concealed a thing with intent to impair its ability as evidence in the investigation. Conceal means to prevent disclosure or recognition of or place out of sight the thing. Destroy means to ruin the evidentiary value of the thing. Thing means an object or entity not precisely designated or capable of being designated. Here, knowingly means a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Here, intentionally means a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it's the person's conscious objective or desire to gauge in the conduct or cause the result. If you find from the proof beyond a reasonable doubt that the defendant is guilty of tampering with evidence, and as the defendant is guilty of tampering evidence is charged in an indictment, then your verdict must be not guilty. Let me read that over again. Come on. If you find from the proof beyond a reasonable doubt the defendant is guilty of tampering with evidence, you will so report on your verdict on your verdict form. If you have a reasonable doubt as the defense guilty of tampering with evidence as charged in the indictment, then your verdict must be not guilty as to that offense, and you shall proceed to determine his guilt or innocence of attempted tampering with evidence as a lesser.
Sorry, we were 2 minutes behind the live feed here, so great. We're at 1.05 speed now.
To the defense. The essential elements necessary to constitute attempt at tampering with evidence have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted tampering with evidence, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted tampering with evidence as charged in the indictment, then your verdict must be not guilty as to this offense, and then you proceed to determine his guilt or innocence on the facilitation of tampering with evidence, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and tampering with evidence have previously been set out in these instructions. Refer to these instructions herein. If you find from the proof beyond a reasonable doubt the defendant is guilty of facilitation of tampering with evidence, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of tampering with evidence as charged in the indictment, then your verdict must be not guilty as to the offense. Then you shall proceed to determine his guilt or innocence of facilitation of attempted tampering with evidence, a lesser included offense. The essential elements necessary to constitute facilitation of a felony, attempted tampering with evidence have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted tampering with evidence, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted tampering with evidence as charged in an indictment, then your verdict must be not guilty as to that offense.
Time for another sip. Shit, we're so thirsty. Shame, Judge. It's okay. You could do it. Look at this. Look at this pile of paper here. There's still quite a bit to go.
This is labeled order of consideration. In reaching your verdict, you should first consider the offense charged in count 1. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least with that count. You shall not proceed to consider any lesser included offense until you first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and then proceed to the next count and follow the same procedure as to each count of the indictment. The crime charged in each count of the indictment is separate and distinct. You must decide each charge separately on the evidence and law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict.
Bertie B says, sippy, sip, sip. You could do it, Judge.
During the trial, you heard the expert testimony of Dr. Dorica Malaska Hawkson. I mispronounced that name, so I apologize to the doctor, who was described us as an expert in the field of forensic pathology. We also heard from TBI Special Agent Douglas Williams, who is an expert in the field of forensic pathology. I didn't say that right. Special Agent Douglas Williams, who was described as an expert in the field of digital forensic, and TBI Special Agent Jennifer Millsaps, who was described to us as an expert in the field of forensic biology and serology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining the fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. In giving an opinion, an expert witness may have testified that he or she took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used only for you in evaluating the expert witness's testimony and cannot be relied upon as proof of the matter, proof of truth of the matters asserted in these statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinion were based on sound reason, judgment, and information. You're to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. The guilt of the defendant, as well as any facts required to be proved, may be established by direct and circumstantial evidence, or both, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact in an issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give to the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to one another, or say that one is better evidence than another. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of different witnesses, you must try to reconcile them if you can, without hastily or rashly concluding that any witness is sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof of any, if any, of his or her general character, the evidence of any of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. The defendant is not taking the stand to testify as a witness, but you shall place no significance on that fact. The defendant is presumed innocent, and his burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing that witness's credibility. and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statement of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness has thus been impeached, the jury has the right to disregard his or her testimony evidence and treat it as untrue, except where it's corroborated by other credible testimony or by facts and circumstances proved on the trial. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which he is charged. In considering the identity of a person, the jury must take into consideration all the facts and circumstances in the case. The court further charges you that if you're satisfied from the whole proof in the case beyond a reasonable doubt that the defendant committed the crime charged against him, and you're satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it will be your duty to convict him. On the other hand, if you're not satisfied with the identity from the proof, or you have reasonable doubt as to whether he's been identified from the whole body of proof in the case, then you should return a verdict of not guilty. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon the testimony alone, you should act upon it with great caution. Give it careful examination in the light of the other evidence. You are not to convict upon the testimony alone unless you're convinced beyond a reasonable doubt that it is true. If from the proof you find that the witness Rebecca Dishman has committed a bad act other than that for which he is pled to with threats related to jealousy in the jail, you may not consider such evidence to prove her disposition to commit such a crime. The evidence may be only considered by you for the limited purpose of determining whether it provides a motive, that is, such evidence may be considered for you if it tends to show a motive of the witness for the commission of the offense charged here, or b, the witness's intent, that such evidence may be considered by you if it tends to establish the witness actually intended to commit the crime charged here. Such evidence of other bad acts, if considered for you for any other purpose, must not be considered for any other purpose other than that specifically stated. The court instructs you there is evidence of an oral written statement given by the defendant in this case. You may take it into consideration with all other facts and circumstances proved in the case. And considering the statement, it's for you, the jury, to say what weight you would give that statement. You may believe any part of the statement or disbelieve any part of it. You may believe the whole statement or disbelieve it in its entirety. Evidence has been introduced in the trial or statements by the defendant made outside the trial to show an admission against interest. An admission against interest is a statement by the defendant which would acknowledge the existence of some truth of fact necessary to be proven to establish the guilt of the defendant, or which tends to show the guilt of the defendant or is evidence of some material fact, but not amounting to a confession. While this evidence has been received, it remains your duty to decide in fact if such statements are true. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. And so determine, consider the circumstances under which the statement was made. Also consider whether any of other evidence before you tends to contradict that statement in whole or in part. You must not, however, arbitrarily disregard any part of the statement, but rather you should consider all the statement you believe was made and is true. You are the sole judges of the weight. You are the sole judges of the weight should be given to such a statement. If you decide a statement was made, you should consider it with all the other evidence in the case and determine the defendant's guilt or innocence. Before the defendant can be convicted of any degree of homicide, the state must prove beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant, by the conduct of another for whom the defendant is criminally responsible, or both. The proximate cause of a death is that cause which, in a natural and continuous sequence, unbroken by any independent intervening cause, produces the death, and without which death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of one or two persons may work concurrently to proximately cause the death, and in such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not an offense if the negligent conduct of the deceased may also have been an approximate cause of death. However, it is a defense to homicide if the proof shows the defendant that death was caused by an independent intervening act or omission of the deceased or another which is likely to happen. However, if in the exercise of ordinary care the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the approximate cause of death. It is not necessary that the sequence of events or particular injury be foreseeable. It's only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. If some other circumstances cause the victim's death unrelated to defense actions, that would be a defense to homicide, unless the circumstances was the natural result of the defendant's act. If you find that the defense acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you've had a reasonable doubt as to this proposition, then you must find him not guilty. Any attempt by a person to conceal or destroy evidence is circumstantial which, when considered with all the facts of the case, may justify an inference of guilt. While that inference is by no means strong enough by itself to warrant conviction, yet it may become one of the series of circumstances from which guilt may be logically inferred. Whether the evidence presented proves beyond a reasonable doubt that the defendant so acted is a question for your determination. If this fact is proven, this fact alone does not allow you to find the defendant guilty of the crime alleged. However, since an attempt by a defendant to destroy or conceal evidence may be caused by a consciousness of guilt, you may consider this fact. If it is so proven together with all of the other evidence which you decide the guilt or innocence of the defendant. On the other hand, a person entirely innocent of a particular crime may attempt to destroy or conceal evidence, and this may be explained by proof offered or by the facts and circumstances of this case. Concealment or destruction of evidence of a crime is not proof of premeditation. When there was an attempt to destroy or conceal evidence by the defendant, the reason for it and the way to be given it are all questions to be determined by you. The court has charged the jury concerning an inference that the jury may make in regard to certain evidence. However, the jury is not required to make this inference. It is an exclusive province of the jury to determine whether the facts and the circumstances shown by all the evidence in this case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or by both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must prove beyond reasonable doubt every element of the offense before the defendant can be found guilty.
Okay, we're getting there. That little pile of paper at the back there is getting smaller and smaller. This one's thankfully getting bigger. Zen Jen said, I'm pretty impressed by the number of people watching right now. Me too. There's about 2,200 people here. Thank you all for being here, for wanting justice for Jennifer Paxton, for supporting her family, for being here, of course, supporting the channel as well by just watching. Thank you so much for choosing to spend your Saturday here with us. That's amazing. Okay, at a trial on a Saturday. Can you believe it?
The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reach an agreement if you can do so without violence to individual judgment. Each of you must decide the case yourself, but do so after an impartial consideration of evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, telephone, cell phone, smartphone, iPhone, computer, internet service, text, instant messaging service, internet chat room, blog, website, Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or to conduct any research about the case until you return your verdict and the trial's concluded. In addition, the 12 jurors may not communicate in any way at any time prior to the conclusion of these proceedings with the alternate jurors who will be selected at the conclusion of these instructions. You will have no credits or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality, as you think justice and truth dictate. When you retire to the jury room, you'll first select one of your members as the foreperson who will preside over your deliberations. When you've reached a verdict, you'll knock on the door there and tell the deputy you've reached a verdict, and then he'll bring us on the courtroom and your foreperson will deliver the appropriate verdict form. If you find that the state has proved the defendant guilty beyond reasonable doubt, then you should find him guilty. On the other hand, if you find the state's not proven beyond a reasonable doubt the defendant's guilty, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. You'll be provided with forms of all possible verdicts in this case. The jury will complete the appropriate verdict form, and the other verdict form will be left incomplete and unsigned, and you will receive these verdict forms. And let me just briefly show you one of them so you can get an idea of what it is. For example, on the first...
Wait, look. There's no more paper there. He did it. He made it through almost 100 pages. I mean, that was the assignment today. Achieved, but damn, that was long, huh?
Of premeditated first-degree murder. Remember, I listed all those lesser-included offenses. So, for example, it says only check one. Guilty of premeditated first-degree murder. If you have a unanimous verdict that you cannot reach a verdict on that, then you have to consider the second one. And we go all the way down. And the last one is not guilty. That's K. And the foreperson will sign each one of those. And I've got one of those for each count. So we need to fill those out. Now, our procedure is a little bit different since this could be, not guaranteed, could be something that the jury has to do sentencing on. So what I'm going to do is in just a second, I'm going to draw out the four alternates. One of the deputies is going to take the four alternates out. And the four alternates will take their jury notebook with them, and then they'll just leave those in my office. Nobody's going to look at them. They'll be protected for you in case you need to come back. And the reason I have four alternates is, and this has happened before in Tennessee, one of our original 12 gets sick, and I have to replace them, or maybe two or three of them, so I'd have to replace them. So I'm not willing to let the alternates go. So my four alternates that I keep here, this is important because we're going to probably go until Monday on this before we come back and do other stuff if we've got to do sentencing. My four alternates cannot discuss the case among themselves, what we've heard, what the law is, anything like that. Can't talk about that. And number two, they cannot have any contact with the 12 jurors. They cannot come around them. They can't talk to them. And my deputies will make sure of that. So that's difficult, right? That's challenging. So, and we'll work on the rooms at the hotel, but be prepared. They're going to keep these four away from the 12. And then we'll go into the next phase, and then we'll see what happens with the alternates then. Everybody understand that? Anybody got any questions about it? Okay. All right. So let's see what our alternates are.
He's gonna pick the alternate. Shame.
My first alternate is juror right here. My next alternate is let me hold on to that one for a second, and I'll tell you why in just a second. My next alternate is the interesting thing was about I couldn't tell if this was a 9 or a 6. So that's the reason I'm going to wait. Well, the next number I drew was a 6. So 9 and 6, you both are alternates. Where's 9? Where's 6? Okay.
Okay. Oh, okay. Yeah, that makes sense. Hey, you said you're going to get it out of your mug. Holding him accountable for what the judge said yesterday. He said it would take 45 minutes to an hour to read through his jury instructions, and we're going to go to that now. It, in the end, took 2 hours and 20 minutes, and he said he's going to draw the names out of a cup. He's drawing it out of a basket.
All right, next alternate is 3. Okay, so everybody rise, and we'll let our alternates go out with our deputy. And you can put their jury instructions and their notebook in our office. Okay? So my alternates are excused. I go with this handsome gentleman right here.
Judge, make sure the officers understand they still be operating.
I've already told them that once. Don't talk about it. Twice. All right, everybody else can have a seat, please.
Ooh, he's looking at them. His life depends on it. At this point, it's just the guilt phase, of course. Later will be the punishment phase. Then Jay says, I don't believe alternates are in the jury room during deliberation. They are not. They are not. They keep them separate. They have to be in a different room. They have to just read a book, not talk about the case. It must be very difficult.
And just now we're going to begin our deliberations. Let me tell you a little bit about that. I'll send the verdict form back there with you. I'm going to send these exhibits back with you as well. In the event you want any of these CDs or this flash drive played for you all, just knock on the door and tell the officer, and then we'll make the accommodation for y'all to hear that again, or if you want it played, but that's your call. But you'll have the other exhibits in there. I'm not going to send back the stuff in the bags, but like pictures and things like that, I'm going to send all those back. Now saying that once y'all hit that door, y'all are now in charge. And so when you take breaks, it's up to y'all when you want to take a break. But now let's say 2 or 3 of y'all say we want to take a break and we want to go outside and smoke. Okay? 2 or 3 can go do that, but you can't go out there and talk about the case. And the 9 that are still in there can't talk about the case. We can only deliberate when all 12 of us are together. I'm probably going to let y'all work to about 5:30 or 6 tonight. If you don't have a verdict by then, I'm probably going to let you go to dinner, and then we'll start back on Monday morning. And that'll be challenging, right? Because between now and then, you can only deliberate in that room when all 12 of y'all are there. And so, so that means tomorrow, you all, even if we reach something today, depending on what the punishment, or depending if you're going to do sentencing, y'all cannot talk about the case tomorrow at the hotel. You can't talk about it at dinner or breakfast or lunch. The only time we can talk about the case, the evidence and the verdict, is in that room. Everybody understand that? Can everybody do that for me? It's really important. Raise your hand if you can do that for me. Okay, I'm counting on y'all. This is critical that we do this correctly. I was kind of waiting for the officer. Can you see if the jury can go back and deliver?
Wow. Okay. So what the judge just said, I mean, now it's 2:20 p.m. if you're watching live with me now in Anderson County, Tennessee. So they're going to send them off to deliberate. If they're not done, wish they won't be. Look at that paperwork. You know what I mean? Damn, imagine that. By 5:30, then they're going to go to dinner, and they're going to have tomorrow off, and then continue deliberation on Monday. Damn. Okay.
Deliberation room yet? And we'll wait just a second. Anybody got any questions about? And if you, I'm not sure it was in the instructions. If you have a question that arises that you need to ask me, all you do is write on a piece of paper, knock on the door, and give it to the officer. But understand, I can only answer questions about the law, and I gave you what the law is. So that's all I can answer. I can't answer about facts or anything like that. So it's very limited about what I can answer. So if you have a question about the law, you can write it down, but understand I'm very limited on that. So around 5 or 5:30, I'll probably bring y'all back in here if you've not reached a verdict by then and say, okay, we're going to break for the evening. We ready? Okay. Thank y'all for participating in this. Everybody rise, please.
Jury, follow me.
And now it's verdict watch time, everyone. Well, I think that's going to be pretty much it for this stream. I've already set up the next stream. That's what I'm busy doing now for you guys, making sure that it's public. You're going to be redirected there, okay?
Thank you. Have a seat, please.
Just pause. If there's anyone new here and you don't know how I quite do it, so Susan says, how will we know when you have a verdict? How you'll know is you'll be redirected to a stream now that's called Verdict Watch, okay? don't look at the time, because I don't know the time when the verdict will come in. I don't have a crystal ball. So the thing is, it'll be a verdict watch stream, and I'll just keep on postponing the time until there's a verdict, whether that's Monday night, Tuesday night, Wednesday, I don't know. So we'll just keep it going like that. And you could chat over there. If there's any questions from the jury, I'll be monitoring, all the court feeds, and I'll type the questions in there. A lot of times, Grizzlies also, or the mods will type the questions in there if I'm like fast asleep, which I try not to be, but I can't like not sleep for days, you know what I mean? So the thing is, we'll go over there, we'll have our chat going. It's not live, it's just a live stream set up, ready to go. When I go live, you'll get the notification as you normally would, okay? If you don't trust YouTube's notifications, if you feel like, no, I don't usually get them, I would suggest heading over to Patreon. I'll make sure that that's a public post when the verdict is in, and not just for the paid patrons. There's public posts as well, so it operates kind of like social media, like X would, right? So if you just head over to Patreon and sign up over there, you don't have to pay anything. Public post, I'll tell you there. The verdict is in. We're going live now. And then we'll be live. So that's how you'll know. That's why I do it that way, so that you'll know, oh, okay, now it's in. Okay, you should get a notification. So make sure you subscribed with your notifications on. Make sure your phone allows for notifications. And then fourthly, make sure you go to Patreon just in case, so that you can get that. And if you don't want to be on Patreon, make sure you follow me on X. My handle is @TrueCrimeGizzler. All my official links are on grizzlytruecrime.com. And over there, I'll also post it when we are live with the verdict, okay?
If you leave the courtroom, if you can just leave your phone number with one of the officers up here so we can call you if we need you. Would y'all like to take a break and then maybe go ahead and do our witness impact statements? Go ahead and get that done, or do y'all? I'm sure you're tired. If you'd rather me wait on doing that, I'll do that. Whatever's easier for y'all. Okay, I've got three, and the way I do it is I ask the family to come up here. I put them under oath. I get them to read their statement, and I found this is better to do it this way because they know exactly what they're saying. And then there's some things I can allow and not allow in the victim impact statements. And so we can go ahead and take care of this before the jury comes back with a determination. So I'll do that without objection to that. But let's see, the first one.
So Judge, I'm sorry, just so I understand, this is kind of like a preview of what we're sentencing?
Yeah, okay. Yeah, except it's really not it's what's going to be.
Yes,
it's the reality of what's
for a second about what's
right.
happening.
Does that make sense?
Yes, sir.
Okay.
But it's for you to gauge whether there is something objectionable.
Correct. That's one reason. And the other reason is, just to make them. I found writing it out makes it better.
Absolutely.
So do y'all want to try? Y'all want to try this? I think my first one I've got is it Beverly? Beverly, you want to come up here and read this to me? Just come up here, please, ma'am.
Okay, so the stream is not ending yet. The judge is a very busy one. He's going to now make sure that they practice their victim impact statements. So he said it's not a practice run, it is what it's going to be. But the jury is not in the room right now, right? So technically it's a practice run of victim impact statements. So let's hear. I don't know how long this will be, but let's hear it. We are together, right?
Good afternoon. How are you? Good. If you'll raise your right hand for me, swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good. So the purpose of this is, I appreciate your writing for me, okay? But there's some things I can allow and not allow by law. And so I don't want to do anything to mess this up.
Yeah.
Okay. So I'll let you read this into the record, and then we'll see if anybody's got any objections, or if I suggest we leave something out. Okay?
I need to write form.
Oh, you're right. Sorry.
My bad. Thank you.
Just have a seat right there, please, ma'am. And if you'll say your first name and last name and spell them both. What's the way just say they close that door?
Okay.
Got it. Go ahead, ma'am.
Beverly Jeffers, Beverly Jeffers.
Thank you very much. If you'll read your statement for me.
Your Honor, I wanted to thank you for allowing me to speak on behalf of our family. Our lives have forever been changed. It is always hurtful to lose someone you love, but it is a different kind of hurt and pain to lose someone you love the way our family lost Jennifer. We didn't just lose Jennifer. She was taken from us. When Jennifer went missing, we all looked all over town for her. Gail, Mill, David, and Brittany looked on the south side of Knoxville. The rest of us took the north side. We looked for her not just for a day or two. We looked for her for months, day after day. Her grandmother, who she called Mom, would call me almost every day to ask if I had seen Jennifer. It was so hard on us. We knew Jennifer wouldn't go for days and not contact me or one of us. Then on August the 6th, 2020, Patty, Jennifer's mother, received a call no mother should ever have to get. They found Jennifer. Patty was so devastated. When she called me, I couldn't understand what she was saying. Then when I finally did understand, I, like the rest of our family, went into complete shock. The most awful thing that could happen to a person and their family did happen. Jennifer was murdered. Jennifer, who was a mother, a daughter, a granddaughter, a sister, a niece, and a cousin. Her mother, Patty, didn't make it through the loss and devastation. She died with a broken heart. Before Patty passed away, she asked myself and the other ladies here with me today to promise her we would be here in court every day for her and Jennifer to show Jennifer was loved, is loved, and forever will be loved and missed. Thank you, Your Honor.
Very good. You honored Jennifer by doing that. That's okay? And you made your promise. You carried out your promise. That's what we're supposed to do, right?
Yes.
Okay, good job. Thank you. I'll take it. And right now, I don't see anything objectionable in that, but I'll talk to the attorneys. If I find anything objectionable, I'll just draw a line through it.
Okay.
Is that okay?
Yeah.
Very good.
So don't worry, we're all confused. Is this the practice? The attorney asked if it's a practice round. The judge said, "Well, yeah, but it is what it's gonna be." He wants to make sure that whatever the victim impact statements are, that there's not things in there that aren't allowed to be said in the courtroom. So I've never seen this before either. New to me. Very interesting. Shame, man. The poor family. Oh my goodness. So that was Beverly Jeffers. Shame.
Great job. Let's see. Next I have, is it Brittany? What? I don't. And this is Miss Payne. Okay, Miss Payne, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And if you'll say your first name and last name and spell them both for me.
Brittany Payne. Can you hear me good?
Yeah, you good?
Brittany Payne. BRITTANYPAYNE.
And Miss Payne, I've reviewed this. I've read it. Perfect. Very good job. You honor your friend. The only thing I feel like I should strike is down there where it says evil is real. Mm-hmm. And I understand you feel that way, and I'm not diminishing that at all. But that may be inappropriate, and I don't want to do anything to mess this up. Okay? So I'm going to draw a line through this. Mm-hmm. So when you have the opportunity to read this in front of the jury, don't want you to read that. Okay? So will you read this one?
Yes, sir.
You see, so there the judge also said when you read this in front of the jury, then it's a practice round. Dizzy said this part usually happens in chambers the morning of before court starts. Interesting. So now they're showing it. You say in the morning before court starts. So maybe the judge is just making sure he gets everything done, ready for Monday in case they go over to Monday. Because if the jury doesn't come back with a verdict today, then he's going to order them dinner. And then he says we'll be back on Monday morning. So maybe that's why. I've never seen this before. It's very interesting. Thank you, Dizzy. Thank you so much for that answer. That helps. This part usually happens in chambers the morning of before the court starts. So the jury's deliberating. So this will probably happen again when the jury's in the room.
Oh, sorry. Jennifer was my first cousin, but we grew up as sisters. I love Jennifer with all of my heart. Losing her has really hurt me. I can't think straight. I have nightmares. Sorry. I have nightmares. I can't sleep right. And this past week, I can't even eat right. I can't listen to songs without thinking of her. It hurts me to know that I will never see her again. I'll never hear her voice again, or see her smile, or hear her laugh. It absolutely kills me that I didn't get to tell her goodbye. Knowing I'll never get these phone calls or messages ever again destroyed my heart. My whole world changed, turned upside down. I'll never look at this world the same again.
Thank you, ma'am. And I've noticed, I've seen you on court every day. And I know you're not here just to see me. You're here to honor your friend or your sister.
Yes.
And so that's a great thing. And you've done that. You've been successful in that. And I can't help but think that she's not pleased that her friends are here lining up for her.
Yes.
Good job. Thank you. Thank you. You can step down. And next is Jennifer Gail Paxton.
No, Your Honor, this will be Michelle, I believe is.
Oh, I'm sorry, I just read her
her
name.
last name, McMahon.
You're right. Where's Michelle?
We should probably have her sign that with her name.
She did. That's all right.
Bookworm said in past trials, the judge reviews the statements beforehand to make sure they conform to the rules, not allowed to address the defendant, only the court. Very interesting. So it really is a practice round right now. The jury is deliberating right now. Okay, so the verdict watch stream is already there. It's set up for you. If you guys just stay here with us, but if you want to make sure your notifications are on for the verdict watch stream, go check that out. And now, so we'll obviously see this again when the jury is back, which I don't know if that'll be today or Monday. They're not going to deliberate tomorrow by the sound of it. Today, if they don't come back with one today, they're going to have dinner. The judge said we'll be back on Monday. So, yeah, he's just preparing everything.
And Michelle, if you'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. If you'll have a seat and tell me your first and last name and spell them both.
Michelle, M-I-C-H-E-L-L-E, McMahon, M-C-M-A-H-A-N.
Okay. And in these victim impact statements, I have to be careful. We can't say anything that would get the jury motivated. Does that make sense?
Yes.
So I'm striking, and when I do this, I'm not being disrespectful to you or your feelings at all.
I understand.
You do? Okay, great. So I'm striking the line that says, I feel that this directly led to her befriending the monster who sits at the defendant's table. Let me see what else we've got here.
Mary, you're like, the judge may be doing this because he feels the jury may come back with a verdict today. And I mean, yes, he actually kind of has to prepare this in case they do come back with a verdict today. Wow, that'll be amazing. Our stream will be ready. We'll be ready for that. Oh my goodness.
And then I'm going to strike out the line that says, and I'm not saying this didn't happen, okay? Because I think this is Jennifer's mom that struggled. I think that's what you're saying. Mm-hmm. She struggled to understand how not just one, but two people, that evil could be so cruel with disregard for another human life. Okay, so I'm going to strike that. Okay. Not being disrespectful to you at all, but just making sure I don't have an issue to have to do this again. And so what's your relationship to Jennifer?
I was her mother's first cousin.
Okay.
Yeah.
I can't say I got it all, but if you'll read that to us, please, ma'am.
I'm Michelle, first cousin to Jennifer's mother, Patricia. First, I'd like to tell you about Jennifer. She was kind and loving. She cared about other people, even strangers. She grew up with a tough life, as many of us did. The difference between her and us is that she never seemed to make peace and get past the hardships of her childhood or upbringing. She never knew her natural father, and partially, I think that distorted her view of what a typical family unit should be. I believe that this led to her making a series of poor decisions in her own life, including the men she chose to try to build a family with. She longed to have a typical, normal American family. She trusted too easily and too much. Jennifer's mother tried the best she knew how in raising Jen, but in her own words, she made a ton of mistakes, especially with Jennifer. Patty was desperate for Jennifer to not make the same mistakes that she had made herself, like becoming a mother at just 15 years old. Because of this, she was way too hard on Jennifer. Again, her words. Not allowing her to have friends. She wasn't allowed to play in the neighborhood like her brothers or hang out with others after school unless it was with family. This is why Jennifer lovingly clung to her grandmother. She felt loved with her. She was allowed to be more of a child with a normal life when she was with her. So naturally, Jennifer had more of a mother-daughter relationship with her than she did with her mother. Jennifer was also a middle child and the only girl to her mother, Patricia. When Jennifer went missing, it didn't go unnoticed by her family, even though she had become part of the homeless community. Many of us searched for her for months, as well as looking at every person we passed as we went about our daily lives, hoping to spot her somewhere, as we always had in the past. Patty, like many other parents of addicts, was terrified of getting that call or knock on her door to tell her that Jennifer had overdosed and was gone. That call came in August of 2020, only it was much more horrifying than she could have imagined. I spent much of the time after Jennifer went missing with her mother until her passing, only 16 months later. She suffered finding out Jennifer's demise after 9 months of searching. Patty was in poor health, but was haunted by the things we were told by investigators of what those people did to her daughter. She blamed herself. She stated and questioned regularly how if she had been a better mom, or if she had tried one more time to help her, if she could have prevented what happened to Jennifer. She thought Jen fell victim because maybe she didn't feel loved enough, or because she had been so hard on her in her life. Patty had nightmares every night of Jennifer crying out in pain or for mercy. She imagined Jennifer begging them to stop and let her just come home to her family. Patty continued in church looking for comfort and trying to find understanding of what led to Jennifer to get in the car. Patty died in the hospital, still crying and suffering over what happened in the Finnegan Dishman home those 4 or 5 days. Patty had battled health issues for years, but after losing a second child in such a horrifying manner, she had just given up. She was tired of regret, tired of the nightmares, the day thoughts. Tired of suffering and missing her daughter, Jennifer Gail Paxton.
I may have to take some things out,
I understand.
but I'll work on that. And, you know, it's hard to understand addiction. I worked with a drug court for about 14 years, and I came to discover that addiction is like cancer. And when you have cancer and it comes back, we don't say you didn't work hard enough in your rehabilitation. And so that's what happens with addiction. It just keeps coming back. And I hope that, I don't know where you are faith-wise, but this is just our temporary home. That's why there's bad things that happen.
I agree.
But there's good things. And Jennifer's in a lot better place.
With her mother.
Not addicted anymore, not hurting anymore, not living under a bridge.
Amen.
She's on top of the bridge, right?
Yes.
Yeah. So celebrate that. Celebrate those wonderful memories that you have. And when the DA talked about her dancing, I love that. What a great memory of somebody dancing with joy. And that's probably what she's doing when we're struggling through this.
I agree.
Okay.
Thank you.
Shame. Oh my goodness, this judge is amazing. I see there's a few people in chat that are like a little bit confused. Like, what is this, right? So this is, in layman's terms, a practice round of the victim impact statements. Probably in case they also, for whenever the verdict comes in, they'll be ready to go. Then there'll be, there'll be the verdict and the victim impact statements. And then obviously then there's still going to be the punishment phase of the trial. But some people are getting like annoyed. But as Dizzy said, thank you, Dizzy, for sharing what you said earlier. That was helpful. Saying this is normally what happens in chambers, before the verdict. So I'm actually feeling grateful that we're able to see this. Normally we wouldn't be able to see this. And so I think it's just part of the normal process. And the judge has to make sure that there's no mistrial or appeals material or whatever, just in the victim impact statements as well. It's being very careful. I think this is what they do. We just don't normally see it, right? So thank you all for being here as we watch this. I feel for the family. Shame, man. And they're going to have to do it again, right? So I have a lot of empathy for them. But I think they're doing so well. And I think the judge, giving them pep talks and, just cheering them on is really wonderful, right? Okay.
All right, so I need to make the next exhibit. Here's my jury instruction. Madam Court Porter, will you make that the next number exhibit? And I'll go through and edit this some more. I didn't catch everything I should have caught. And I'll show it to counsel before we do the victim impact statement so y'all can look at it again. Anything else for the state I need to do?
Just for the record purposes, I brought over the laptop, and if you wanted to look at that to just ensure you're satisfied there's nothing on it.
I'm satisfied, but I'd like you to.
We discussed it. It is a computer that's provided for the purpose of looking at CSAM material, so it cannot be networked. And for any files that were on it, I've deleted it, and the quick access. So you would never be able to open it anyway since the file's deleted, but you can't even see the file path name that was on there, and emptied the recycle bins.
You plan on staying around or you go back to the office?
I'm going to be in the office. I could leave this here.
Okay.
The password is on a
If we can't figure it out, we need your phone number to call and say how to turn the thing on. Okay.
Thanks, Judge.
Anything else I can do? Okay.
Mayor.
And then I think we've still got a motion in limine in regard to the aggravators.
Judge, I misspoke. That's going to be a proposed jury instruction.
Later.
Yes, sir.
Okay. So yeah, whenever you get that to me, I don't need it right now, but sometime I'll need it.
Yes, sir.
Okay. All right. And so if y'all leave, just leave your phone number with one of the officers or with Miss Jones, and we'll call you if we get a verdict or if we have a question. That's normally what's going to happen. I get a question next. Okay. All right. Thank y'all very much.
Thank you, Judge.
Okay, so verdict watch is official, everyone. Okay, so now it's time for the verdict watch. That was quite a busy day, hey. Okay, Little Miss was asking me, so I just want to answer Little Miss's questions because maybe you also have the same question. This stream will now redirect you to the verdict watch stream. I've set a time for Monday, 6 o'clock my time for now. I think 6 or 11 or something. I set a time for like Monday night my time. Of course, I am 6 hours ahead of Anderson County, Tennessee time. It's just just a time I put there so that we have the stream, but I might have to postpone if the jury takes longer, of course. The thing is, if you click notify me, you will get a notification when I go live, because I will not go live until there's a verdict. Now, Little Miss said, I have notifications on, but they don't always work. If they don't always work, please come over to Patreon, okay? On Patreon, a lot of my notifications for public streams like this on YouTube are public over there, meaning you could just sign up and everything and you will get it. As long as you sign up there, you don't have to pay or anything. You don't have to join as a paid patron. Of course, if you want to, that's fantastic. There's lots of exclusive perks and it's a great support for the work that I do. But if you just join over there, sign up, you will get the notification to your inbox as well, or via the Patreon app. So there's many ways to get it. Or follow me on X. My handle is @TrueCrimeGizzler. Make sure you follow the right one. There's a couple of imposters there. Okay, @TrueCrimeGizzler. And I will post as well over there. And many Grizzlies always repost as well. And I repost what they post. So thank you so much to everyone who does that as well and alerts everyone what we're doing. So you've got YouTube, select notification on. You got Patreon, you got X, and hopefully you will be there with us when the verdict is in. Fletcher Boy said the jury is determining the sentence. An improper statement could cause a mistrial for sentencing portion. Yes. Thank you so much, Fletcher Boy. So yeah, they have to be very careful, of course, and do everything right, which the judge is doing. The judge is amazing. I think this judge is, when, as someone said earlier, we'll miss him when this trial is over, right? I think he goes on our honorary judges list, right? Okay, so are we ready now to teleport? Are you ready? Are you buckled up? Because what I'm going to do now, I'm going to put it in the chat now. Here we go. Look, verdict watch here. Okay, so you can either click on that and go over there and click notify me and chat over there. If there's a jury question, I'll usually type it over there, or someone will type it over there, because everybody's always lurking, always watching, seeing what's happening, right? Email me as well. If you see there's a jury question and you want to email it to me, that's always very helpful if you type out what they asked so that I could just read it out when we go over it again, maybe for the verdict when it comes in. So head on over there, click notify me, feel free to chat over there, and I will see you live on that stream. And I'm saying it like that in case we talk about anything else tomorrow, other streams, whatever. In this case, for this trial, I'll be live on that stream when the verdict is in, okay? Not any time before that. Are we ready? Yeah, Shauna said, I told you this judge was a kind man. Few judges allow the victim impact statements to be read in front of the defendant before the edit, and he can't respond when the jury's present. I know, right? That is amazing. Okay, here we go, guys. Let us teleport. The stream should automatically redirect you there. If not, click on the link. I'll share it again right now in chat. Bye, everyone.